Do you have my weapon set up for war?
Cool. Oh man, I played the wrong one. It's supposed to be the long intro. Anyway, what's up, guys? So, as usual, I am goofing off, listening to stuff, reading stuff that's mind-numbingly insane. So, I figured I'd go ahead and go back to a couple sets of older oral arguments, and then maybe we'll hit. There's another couple topics to kind of hit, just to hang out on a Saturday and go over the insanity. Um, Especially that now that we're looking at.
We'll now call case number.
I don't want you to play yet. Especially now that we're looking at Todd Vandermine and his lawsuit about the ammunition tax in Chicago and all that. I figured it'd be cool to go back through some of the old oral arguments over these things and take a look and see how these judges acted then. And you can tell a definite history with these people that they really don't give a rat's ass about the Constitution, whether it's federal, whether it's a state constitution, you name it. They really don't care. They are all about their opinions, their anti-gun rhetoric, and that's what they're going to stick with regardless. So we're going to play this. This was the. Let me give the right case here. So this was the Gun Save Live Inc. versus Ali, however you want to pronounce retard's name. So we're going to play it. We're going to listen to it. And definitely, of course, listen to the way these judges question the attorneys, and listen to the way the attorneys for the state actually talk about our rights. It's either in this one or the next one where the attorney for the state says it 100% that the Second Amendment really isn't a right. It's not, doesn't matter. I can't remember the phrasing, but you'll hear it. And it's okay if it's not a right. Why does it say it's the right of the people, and why does it say it shall not be infringed? I'm still searching for that.
126014 Gun Save Life Inc. Et al. Versus.
I'm not gonna let this play. I'll be listening, but I got to get a cup of coffee, or I got to warm up my coffee.
Yeah, sure.
Mr. Jimenez, you may proceed.
Thank you. Good morning, Your Honors, and may it please the Court, Pete Patterson for the appellants. Laws that single out constitutional rights for special taxation are repugnant to our constitutional tradition. This Court and the United States Supreme Court have struck down such laws in contexts as varied as the freedom of the press, the freedom of religion, the right to marry, the right to vote, the right to travel, and the right to access the courts. And yet, despite this long and unbroken tradition, the Court of Appeals upheld Cook County's law singling out Second Amendment rights for special taxation. Unless the Second Amendment is a second-class right, which is a proposition that this Court and the United States Supreme Court have already rejected, Cook County's taxes must be struck down, and the decision of the Court of Appeals must be reversed. Incredibly, the Court of Appeals did not even cite any of the cases striking down taxes on constitutional rights. Two of those cases are particularly pertinent here. First is the United States Supreme Court's decision in Minneapolis Star and Tribune. In that case, the Supreme Court struck down a Minnesota use tax on the paper and ink used by newspapers. The court applied strict scrutiny despite the fact that the newspaper's burden under the use tax was lighter than the burden the newspapers would have had under the generally applicable sales tax, and the court struck down the law under that review, holding that there were plenty of other options Minnesota had to raise revenue, particularly generally applicable taxes. The second case is this court's decision in Boynton, which struck down the portion of the Illinois marriage license fee that was a tax that went to fund programs to combat
These governments
domestic
know
violence.
they can't ban
The court
things, so they
said
tax them.
that under Minneapolis Star and Tribune,
It's
because
the
it's
entire
a tax
scheme of the
on a
NFA.
fundamental constitutional right, it must be subject to strict scrutiny. And again, in that case, there was no evidence that anyone's marriage plans were affected by this tax, and yet the court subjected to strict scrutiny and struck it down. Under these cases, there is simply no way to distinguish Cook County's tax on firearms and ammunition, and they must be struck down under that authority. The district court made several errors in its reasoning upholding, or the Court of Appeals, I'm sorry, made several errors in its reasoning upholding
Do you
these
need the
taxes.
plug tablet back?
First, it said they're not prohibitive.
You gotta go
But that
potty,
is
go
not the
potty,
law.
go-
In the Second
Go,
Amendment
go, go,
context
go.
particularly, this court in Shirez rejected any substantial
Gotcha.
burden requirement before getting to heightened scrutiny. But perhaps more importantly,
I'll
in
be
the
right back. Let me plug this
taxation
stuff back in.
cases, there is no burden analysis. As I explained in Minneapolis Star and Tribune, the tax burden was actually lighter for the newspapers under the use tax that was struck down. In Boynton, there was no evidence that anyone's marriage plans were affected. It is the fact of the special tax that constitutes the burden. And this is a tradition going back over 200 years to the Supreme Court's decision in McCullough v. Maryland, striking down Maryland's attempt to tax the Second Bank of the United States, where the court said, quote, "We are not driven to the perplexing inquiry so unfit for the judicial department, what degree of taxation is a legitimate use and what degree may amount to the abuse of power," end quote. And that is the same principle that's been applied in all these cases. It is the fact of the illegitimate tax that is the problem, and there is no inquiry into how practically burdensome the tax is. And
May
in
I
it,
ask you a question to
Looks like my video's
section
holding
of
steady.
the Heller decision,
Okay.
the seminal case,
Yes.
in which Justice Scalia said, "Nothing in our opinion should be taken to cast doubt on long-standing prohibition on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in
and that's why I've said it plenty of times. Heller was a horrible, horrible written opinion.
sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms." Pretty clearly, the Heller decision looked at the issue when there is
Because clearly, if something has been infringing on your rights long enough, all of a sudden it's okay. Like slavery, that should have been fine. It was happening for a really long time. Who cares? They've been screwing you over when it comes to your rights for a very long time. Who cares? It's been going on long enough. Hey, it's it becomes precedent, becomes law. Fucking. And these judges will use this stuff just to keep chipping away at rights, even after Bruin comes down. All these other decisions, they don't care. They go with their ideologies. They don't go with the Constitution. That's how we end up in this screwed up situation that we're in a lot of situations around the country.
the commercial sale of arms, and that's specifically what we're talking about here. How does Justice Scalia's language there affect this case?
yes, there are several reasons that does not affect the outcome of this case against us, Your Honor. First is this court in Shirez held that even Heller's presumptively constitutional regulations of Second Amendment rights still must be subject to heightened scrutiny. So as an initial matter, it is, it doesn't affect the ultimate analysis of the court. But even beyond that, this is not a condition on the sale of arms. This is a tax. It's very explicit in the ordinance that it is on the consumer. It is to be paid by the consumer.
And see, with this particular case, this shouldn't even have reached the level of arguing about the Second Amendment in the first place, because the state constitution itself says you can't do it. But these judges upheld this. This was the first case with Guns Save Lives. In the second case, I think they got overturned on a lot of stuff. But still, that was used in the next case, which was, Vandermine's case. And these judges are just going to continue to uphold this shit until they are removed from the bench for doing stuff that's unconstitutional. They're still going to be doing this.
If the seller does not collect it.
Just help me with the language. A condition on the commercial sale of arms. So and commercial sale certainly includes a buyer and a seller.
It does, but I mean, our submission is what Heller had in mind was things like, certain requirements that sellers have to go through to qualify to sell arms. But even leaving that to the side, Heller used the word long-standing. And this sort of regulation is not long-standing. In fact, to our knowledge, the only two in history that have ever been in effect are Cook counties and Seattle, and both were in the 2010s. And that
Can I go back to the language? Long-standing.
Yes.
This paragraph is separated in commas.
Because it survived long.
Then
it's okay now.
Prohibition on the possession of firearms by felons
Regardless
and the
of what
mentally
the
ill.
Constitution says.
Or laws forbidding the carrying of firearms in sensitive places, or laws imposing conditions and qualifications on the commercial sale of arms. You're suggesting that all of those three different exceptions to the Heller case must be long-standing. Is that follow the rules of parsing
What
grammar?
should matter is the original meaning
I don't know.
Constitution.
There's a rule of the last antecedent. I don't know about the first antecedent, but it is, regardless of the grammar, we would submit longstanding applies to all. But at Heller, the point is you look to the founding. The scope of the right is established at the founding when the right was adopted. So that is the key point to look at, and it's clear.
And see, if Scalia had nailed that down, that if you go to the original text, the original meaning that was agreed to in the first place, and that's exactly what it means, period, it would have solved a lot of issues. We would have got to a lot of wins a hell of a lot sooner. But he punted on a lot of it and tried to make it more palatable, and they just keep beating us over the head with it.
That at the founding, there was a right to acquire firearms, to purchase firearms. In fact, members of the militia, which was the whole body of male citizenry at age 18, under the Militia Act of 1792, had to acquire a firearm for themselves when they turned 18. Every person in every male in the country,
and ammunition,
with minor exceptions. So it's clear that there was this right.
In their case.
And it's also clear that these taxes burden that right. It is a direct tax on the acquisition of firearms and ammunition, which the Northern District of Illinois held is the most fundamental prerequisite to the exercise of the right to keep and bear arms. And the novelty of these taxes underscore their illegitimacy. In Grosjean, where the Supreme Court struck down a tax on
it's experience. She comes in and hands
the court
me
said, quote, in view of the persistent search for new subjects of taxation, it is not without significance that so far as we can discover, no state during 150 years of our national existence has undertaken to impose a tax like that now in question. Here, now we're over 220 years, and similarly, these are novel taxes that have not been tried by other jurisdictions. It only heightens their illegitimacy.
Counsel,
Yes.
the list that Justice Tice read.
This is when you know a shotgun had a bad day.
Were clearly regulations and conditions under the police power.
Yes.
So when we look at something in Seriatim,
Yes.
would the third then
Well, that
theoretically
takes hard
also
work.
be conditions and qualifications under the police power generally, or could they also include
that stuff we got?
taxing?
Yes, I think it would be the police power, it would be conditions and qualifications on the sale of arms to ensure, integrity and safety in those transactions. not
No barrel.
applying special
He's got
taxes
four
to
into
those
it.
transactions to raise revenue, which
So
would
must
be
not.
make the Second Amendment consistent with all other constitutional rights, where they're subject to the police power in certain circumstances. In the
We don't
Boynton case itself,
manufacture.
this court said marriage is
Trying to
subject
be
to reasonable
368.
regulation, but it's not subject to taxation.
Enough.
Same in the Murdoch case. The Supreme Court said
Shotgun receiver laying
the
around.
evangelization that was at issue in that case sometimes gives rise to issues that the police power has to deal with, but the tax power is different. We don't single out constitutional rights
It's not for
for
nothing, it's
taxation.
part of the-
And while that's clear under the Second Amendment, it is particularly clear under this state's Constitution, Article 1, Section 22, which says subject only to the police power, the right of the individual citizen to keep and bear arms shall not be infringed.
Counsel, is there a problem then with any sales tax on the sale of weapons or ammunition?
Absolutely not. And that is the critical distinction
Probably try to
that
track.
has been drawn by all of these cases,
Serial number.
Your Honors, that there is a difference between a generally
Pretty
applicable sales
receivable.
tax,
It's gorgeous.
which is not targeted at the exercise of a constitutional right,
They know
and
them.
a tax that singles
Wood.
out
Damn good
and
quality
applies
wood.
a special tax to the exercise of a fundamental constitutional right. Again, in Minneapolis Star and Tribune, that was the key distinction, and the court said the sales tax would have been fine,
Look at
even
the
though, as
grain
Justice
of the wood.
Rehnquist said in dissent, the
Pretty good.
burden under the sales tax would have, he estimated, 3 times greater than under the use tax.
I would
Nevertheless,
damn near
that
guarantee
was
I
the
could
key
send a picture of
distinction.
this to Mark
So again,
Murdoch.
we would submit that is the key distinction here.
Does it make any difference that the?
I can't
the
dig it
status
up doing a
is
little
on the
research. I probably will ask,
Versus on the seller?
because Night Strike knows more.
Well, to the extent it makes a difference, it is in our favor because it's clear that you are then taxing the individual exercise
Oh, yeah.
of that constitutional right. And
Pretty good.
it is not in any way a regulation of the seller. Perhaps, as the language in the Supreme Court indicated, there could be more room for
Yes.
regulations of sellers. But, I mean, we would submit even a tax on the seller would not be legitimate, but it just makes it that much clearer that here it's on the consumer.
That,
No, that goes, that
And
one goes the one
the Court of Appeals also relied on the Second
the other
Circuit's decision in Kwong, but that decision actually favors us because, again, there the court upheld a fee on firearm permits in New York, but it said the reason it was upholding those fees is because it was not a revenue tax. Instead, it was to defray the expenses of the licensing system that no one challenged in that case. That's the same line this court drew in Boynton, where it struck down the $10 tax on marriage licenses, but did not disturb the $15 part of the fee, the $15 fee that otherwise was in place for administering the licensing system. And there was some, going back to the initial point I made about the prohibitive nature of these taxes, which, as I explained, you don't need to get into any analysis of the
these
practical
judges will
burden of
go
these
to
taxes.
anything,
It's clear that they're not de
any
minimis
mental gymnastics they
under,
have to get up with the state's
the
case.
cases that have been decided. It's a $25 tax on firearms. In Boynton, you had a $10 tax on marriage licenses. In Crocker, it was a $5 tax. In Harper, it was a $1.50 tax on voting. In Crandall, it was a $1 tax on travel. So again, it is the fact of the tax that is the burden, not the amount. Quickly, we have an alternative argument under the uniformity clause, which this court need not reach, but if it does, we again submit that Boynton controls this decision. There, the court held that a tax on a fundamental right is not a reasonable way to raise revenue to pay for general welfare program under the uniformity clause. And we have the same structure here, where it's a tax on a fundamental right meant to pay for general welfare programs. Here,
Again, look at the
ammunition
NFA.
tax
The NFA is a
directed at the
taxing
Public
scheme.
Safety Fund. The firearm tax is
Not a criminal law.
not directed by ordinance into any particular fund. So it's the same structure, and this is not a reasonable tax. And if anything, the case for the government was stronger in Boynton. As the case indicates, there was substantial evidence in the form of expert and statistical reports tying domestic violence to marriage. Obviously, a lot of domestic violence takes place within the marital context, and the court nevertheless said that that was an illegitimate means of raising revenue to combat domestic violence. And here, the evidence indicates that the overwhelming majority of criminals do not purchase their guns at retail, so they're not going to pay this tax. That was part of the basis of the Northern District of Illinois' decision striking down Chicago's ban on gun stores. They said criminals don't typically purchase their guns at gun stores, so you're just burdening the law-abiding citizens of Chicago. And the county cites, or the county cites some things in their brief in this case, including a compilation by a newspaper of 71 shooting incidents by CCL holders, but that clearly can't carry the county's burden under the uniformity clause.
Let me ask you that along that same line.
Sure.
There is certainly an argument, maybe not well developed, but
Right.
there's certainly an argument being made here by the county that gun violence brings a financial burden. Gun violence,
doesn't-
specifically here, they're just speak of how
It doesn't matter, lady.
courts are
Our rights aren't dependent on what criminals do with their
cases of
guns.
murder and armed robbery.
not. They never have been.
battery
Never
by-
should be.
with a firearm. That there's that gun violence brings a cost. Additionally, they argue, although it's not quite this case, but they argue that Cook County Hospital, the Cook County Public Health System, has a huge burden of millions of dollars that are
So she's
expended
back to complete interest
to
balancing.
treat gun violence
Horse
victims.
crap.
So their argument is that there is a financial cost here, and that somehow a tax is related to alleviate that burden. And I think the question that we have here is, as it is in so many of these other cases, where is the relationship between the good government policy here, the cost of gun violence, and the tax itself? In your view, is there any relationship between the burden of gun violence and the cost of gun violence and gun ownership?
No.
It's not been established, Your Honor, whether the cost is positive, negative, whether the net cost. Sure,
And
there
none
are
of that,
costs,
none of that interest
but there are also
balancing is
costs
even
in
fucking
preventive
constitutional
crime
anyway.
from people owning guns. The county has not attempted to perform some empirical analysis, but in any event, in Boynton, there were costs.
But
from
these are the
domestic
mental
violence,
gymnastics.
and
these
many of those
people
costs
do.
were coming from
And
marriage.
they're still
And there
doing
was
it.
expert evidence in that case to that effect, and yet the court said it didn't matter. Here again, I said we have 71 shooting incidents. The first incident in that
What's up, Gabe? What's going on,
compilation
my brother?
was a woman who said her boyfriend shoved her against the wall, killed her.
This
So
was
she
one of the
shot.
cases,
So these were not criminal incidents
about the ammo
necessarily.
taxes in
And those are the
Chicago, in
types
the
of
Chicago area.
that the county is saying we need to tax. That is simply
But
not.
they also,
yes.
I mean, the money is going to the Cook County courts, the state's attorney, the public defender,
Doesn't
the
matter.
Cook County jail.
Your law-abiding
That's where the
citizens
money
are
is
not
going,
responsible for that
in
shit.
terms of this tax, specifically to support the criminal justice
And it
system,
hasn't stopped
where
a
there's a
goddamn
huge
problem.
amount of cases based on gun violence.
Yes, and the answer is in Minneapolis Star and Tribune, where it says if the county.
Yeah,
if
the reason I wanted to go back
raise
through
revenue,
these was
there is a
Todd
much
just, he's got
less
a case very
restrictive
similar to
alternative
this
that
that
would
was
burden
argued just
substantially less
last Wednesday, I think.
protected conduct, and that is a generally applicable
And these
tax.
judges in Todd's
That is
case
how
talked
we
about this
fund
crap.
programs in this country, not
Too many
by
choices. What's up,
taxing
brother?
the exercise of constitutional rights. You could imagine a similar argument in other cases. Under the Fourth Amendment, there are costs imposed by defendants imposing their Fourth Amendment rights. We couldn't tax the exercise of a Fourth Amendment right because of those costs. Similarly, any sorts of rights that involve the criminal justice system. We can't tax criminal defendants for exercising those rights, even if they impose costs.
We do
Just
make
talking
them pay a
about
fee.
people on the screen.
Well,
Go.
and that is to defray the operation of the system, which is the line that has been drawn. If there is a licensing fee, for example, you can defray those costs. And that was the line in Crocker, where it said, there are court fees, but you cannot place an additional court fee for divorce to pay for domestic violence, because that is a general welfare program here. And that is what we have in this case. Everyone admits this is a pure revenue tax. Sure, it may go to pay for certain
Again,
things. Again, the
By
firearm
their
tax is not
constitution, the
directed
state
to any
constitution, it
particular
says the
fund,
government cannot do
unlike the ammunition tax. But this is a tax for general welfare.
it.
It's a
Should have
revenue-raising
never
measure.
gotten
Cook
past
County
the
is
state
preempted
judges,
from
much less
regulating
move
firearms.
to
So this is
federal
clearly not a
circuit.
regulation on their view. If it is, we argue it's preempted, but we think the better reading is it's a tax and that it is unconstitutional
Yeah,
for
Gabe.
that reason. And I see my time has just
They
expired.
don't even want you to have ID to vote, and they argue that it poses a burden on people. Much less, hey, you got to pay $5 to vote.
Ms. Jimenez?
And tell COVID protocols and stupid shit. What?
Good morning, Your Honors. May it please the Court, my name is Martha Victoria Jimenez, and I'll be arguing on behalf of Appalese Zara Ali and Thomas Dart, both in their official capacities as well as the Cook County Department of Revenue.
The state's attorney.
This court should uphold the ruling of the appellate court in its entirety, finding that the Cook County firearms and ammunitions tax are a proper exercise of Cook County's home rule taxing authority. They would stand scrutiny under the Second Amendment in the Illinois Constitution. They are not preempted by the FOID Act or the Firearm Concealed Carry Act. There's no
They just
uniformity
stack
clause
on
issue.
more and more BS
And plaintiff
to
Max
try to
and
keep
Shooter
people
Supplies
from
lack standing in this case.
legally owning arms.
Justices, the Illinois Constitution allows home rule entities the power to exercise any function pertaining to their government or affairs, including the power to regulate, the power to incur debt, and most relevant for us here today, the power to tax. These powers are to be construed liberally, and this court affirmed that in Mulligan v. Dunn,
They could
where this
tax
court recognized
carrots
that the
because
framers of the 1970
carrots aren't
Constitution
protected
considered the
underneath
power to tax
the
to be
Constitution,
essential to effective home
but
rule.
not a
The
constitutional
General Assembly
right.
intended home rule to give entities the power to devise local solutions to local problems. Because different home rule entities have different challenges, a solution that will work for Kane County will not work for Vermilion County, and something that works for Vermilion County will not work for Cook. In Cook County is unique in that gun violence strains the county's already limited financial resources. As Your Honor mentioned, Cook County Health and Hospital Systems is the second largest
So you
public
put a
hospital
tax
system
that
in the
affects
country.
the people who
And in
aren't
2017
causing the
alone,
problem.
it treated 1,100 gunshot patients, spending anywhere from $30,000 to $50,000 on each. This doesn't include the staggering expenses borne by the Cook County sister criminal justice agencies that actually have to deal day-to-day with gun crimes. The taxes at issue are a local solution
They
that
put a
was
tax on
devised by the
methamphetamine
county
and crack
to
rock.
defray these staggering expenses unique to Cook County. Not every home rule entity might choose to do this, but this is the elegant solution that the framers intended. It allows home rule entities like Cook County the freedom to
Elegant
enact a
solution.
solution like this, and it also gives the counties like Kane and
One way to
Vermilion
put
and
it.
all the rest the freedom not to do it. Again, it's that freedom that's at issue in this case. And plaintiff now concedes that the taxes at issue are just that, they're taxes, not regulations.
Counsel, do the home rule powers under the Illinois Constitution preempt Article 1, Section 22?
No, Your Honor. It's our position that they do not. First off, they're taxes. And to the extent that both courts below already ruled that the tax was not an infringement, we don't believe it falls within, that it violates Article 1, Section 22 of the Illinois Constitution.
I don't know that the appellate court, when I'm looking at how they handled Article 1, Section 22, they seem to treat it as the exercise of a police power, which it's not, and you're not saying it. You're saying this is a tax. It's not an exercise of police power.
She's saying that the
Article 1, Section 22
government
says
wins no matter
it's
what, is what she's
And
saying.
The appellate court
No
said
matter the
to gloss
Constitution, no
over
matter your rights,
by
no matter the
using police
burdens, the
power.
government always wins. That's the state's position.
Well, Your Honor, whether you consider it a use of the police power or whether you adopt our view, which is that it is a tax, it's our position that it doesn't meaningfully infringe on the Second Amendment right, and therefore it doesn't fall within the purview of Article
Yep.
1, Section 22.
What's up, Warsaw?
Counsel, are we looking at strict scrutiny? Is that the test?
No. You heard plaintiffs mention during their opening that because the Second Amendment right is a fundamental right, it should be subject to strict scrutiny, and that that's the case for all fundamental rights. That's simply not true. There's a framework already in place, for example, in the First Amendment context, when you deal with freedom of speech, that the level of scrutiny in First Amendment cases depends on the type of limitation that's in place. If you have something that's a content-based limitation, then strict scrutiny would apply. However, if you have a limitation that's content neutral, intermediate scrutiny applies. So no, Your Honor, to answer that question, I would say that, well, first off, the taxes don't infringe the Second Amendment right, so you don't have to get to step 2 of the analysis. But if you were to, it's our position that intermediate scrutiny would apply, because intermediate scrutiny is the law of the land in the Seventh Circuit. It's what it's what courts and cases in Illinois and in the Seventh Circuit have used to analyze laws that encroach on Second Amendment activity.
It's a de minimis infringement? Is that what your argument is?
It's a de minimis, yes. It's a de minimis
but-
insignificant burden on the acquisition.
All it says is it has
firearms
to
or
be an
ammunition.
infringement, and then it's unconstitutional.
No, I'm sorry, I misspoke.
It doesn't say it has to be a big
infringement.
infringement.
What's the difference between a burden and an infringement?
To our view, anything that's a burden is something that would have a prohibitive impact or that somehow stand in the way of an individual being able to exercise their Second Amendment rights.
For
and
driving
this
up
is
the
not.
cost to where people can't afford it, it's not a burden at all.
Which set a $10 fee, may be de minimis, but once we give you the power to tax, then all of a sudden it turns into a $1,000 fee. This is a $25 fee that if we give Cook County the right to tax, could turn into a $250 or $2,500 fee, especially based on the preamble to the statute, which is basically, we're doing this to try and keep guns out of the system.
Well, Your Honor, as far as what's in the preamble to the enactment, we would say that the definitive statement of the legislative intent is in the actual language of the enactment and not the preamble. So Your Honors need not engage in looking at sources that are
don't pay attention
extrinsic
to our
to the
motivations.
actual terms of the enactment. And inside the tax ordinance, it makes very clear that
And we told you
this is a
exactly what
tax
we were
that's an
trying to
issue.
do.
And to the extent that plaintiff relies on Boynton, it is our position that Boynton is a highly distinguishable case. Not only does it not relate at all to the Second Amendment, it's different because our Supreme Court in Heller has limited the right to keep and bear arms, and it is not, and there isn't any kind of Supreme
And that's
Court
why I
finding
say
that
Heller was a
limits
horseshit
thusly
decision.
the right to marriage. So really, the case is not applicable. And Minneapolis Star and Tribune, the other case that plaintiffs cite, is also not a Second Amendment case. It deals with the First Amendment. So in that way, it's also not applicable and highly distinguishable because the county taxes at issue only apply to all purchasers, not the small group of purchasers that the court was concerned with being singled out in the Minneapolis Star case. But again, Your Honor, if I may continue, nevertheless, if this court disagrees and finds that a full Second Amendment inquiry is needed, the taxes would stand heightened scrutiny because of their close relationship to the county's strong stake in reducing the fiscal burden created by taxes in Cook County.
Back to the entrance
Firstly, the
balancing.
ordinance is presumed to be
Screw your
constitutional,
rights, screw what the
and this
Constitution
court
says,
is
screw what
bound
the
to
state
construe
Constitution
and uphold
says.
its validity if reasonably
Just
possible.
fuck all that.
It's plaintiff's job to show you in this facial challenge, which is the hardest to mount, that there's no set of circumstances under which the ordinance might be valid. Plaintiff has failed to do so, and the taxes do not burden the Second
And
Amendment.
now we see judges out of the
In
ninth
Heller,
completely blowing off
the
a
Supreme Court
decision.
ruled that our Second Amendment protects an individual right to possess firearms for traditionally lawful purposes, like defense in the home. But importantly, as Justice Tice pointed out, it is not an unlimited right, and the opinion was not meant to cast doubt on longstanding prohibitions on firearms, including laws that cast conditions or qualifications on the sale of arms. The Cook County tax is merely one of those presumptively lawful conditions that the Supreme Court intended to exist in Heller. We don't think there's a meaningful limitation in that clause to actually only be limited to firearm sales, that it was somehow only meant to sanction limitations on sellers. And that's the case because it's my understanding that there's no Second Amendment right to sell arms, and plaintiff didn't show any evidence.
There's a Second Amendment right to own arms. That means someone has to produce said arms, such parts and pieces of those arms. And since they don't just give them away, they have to sell them, just like paper for the printing press, just like ink for the printing press, just like internet service to be able to post things online, just like someone selling you a computer for your First Amendment right, where you can get on there and type your stupid ass opinions on a device that would have got you burned at the fucking stake for being a witch when the Second Amendment was written. And then you say, well, you know, technology doesn't affect your First Amendment right, but it definitely affects the Second Amendment. You're a fucking moron.
To the contrary of that. So, importantly, because Heller didn't set a doctrinal test, the circuits were left to themselves to sort of fashion out how to interpret laws that infringed on Second Amendment activity. And in Ezel, our Seventh Circuit borrowed from the First Amendment framework, which this court followed in People v. Chires. Now,
can I ask, what's the split between taxes that go to the general fund, the tax revenue from this that goes to the general fund, and the public safety fund that is geared towards?
It's simple. You can't raise money off of people's rights.
well, Your Honor, just as a point of clarification, both taxes end up going into what is in essence the general Cook County Fund that goes to fund the criminal justice agencies that are at the forefront.
The ammunition fund?
Yes. It also goes there as well. And I really have to take a few steps back and sort of point out sort of the de minimis nature of even the funds that are recouped. I mean, in 2020, the Cook County budget was in the area of $6 billion for the entire year. And the county recouped about $1.8 million as a result of the Cook County firearms and revenue tax. So it didn't make sense to parse it out any further than that for it to go to any special use place other than just the general budgets for the agencies that have to deal with
Eagle Run, what's up, brother man?
which include the Office of the Chief Judge.
Been watching your
who,
content from SHOT Show, man.
Presides over all gun cases. The
Great.
State's Attorney's Office, which has to prosecute them. The Public Defender's Office, which has to defend those cases. And the Cook County Sheriff's Office, which has to house all the people that are charged.
Well, the laws are passed for public safety,
Yes.
but then if it's in the general fund, how does that happen?
I don't know.
So again, you're getting back to taxing and basically trying to restrict the rights of individuals who aren't committing crimes to pay for the people who are committing the crimes. It's not their fault. It's the ones actually committing the crimes. But again, this isn't really about them anyway. It's merely about restricting someone's ability to actually purchase and possess arms and ammunition. That's what this is about.
Understand your question, Your Honor.
If it all goes to the general fund, not all of it's going to public safety.
No, but it nevertheless ends up in the coffers of the agencies that deal with gun crime. It goes into their general budget.
Right.
If Your Honor's asking what happens to them after they get there, are they earmarked or sent for a particular purpose? No, they're not. They're spent as part of the general funds to that agency. So, Your Honor, getting back to the two.
Oh, what happened there? Something didn't go all the way through. So let me do this. Let me pull something back up. I might have to pull it back up on YouTube because that shouldn't have stopped there. It should have been the complete oral argument. So let me see, because I know I've got this saved somewhere. Should be here. Okay, so let me get back to where we were at, and I'll get this back on screen. Let's see. Let me go back to a screen share. Let me pull this over. This is a little bit behind,
With the First Amendment.
so I'll try to speed it up.
So in that way, it's also not applicable and highly. What is in essence the general Cook County Fund that goes to
That's close
fund
enough.
the criminal justice agencies that are at the forefront. Yes. It
I don't
also
know
goes
why
there as well.
that.
And I really have to take a
video
few steps
didn't-
back and sort of point out sort of the de minimis nature of even the
Well,
funds that are
well,
recouped.
Well, she's running
I mean,
behind.
in
Let me step out for a
2020,
second.
the Cook County budget was in the area of $6 billion for the entire year. And the county recouped about 1.8 million as a result of the Cook County firearms and revenue tax. So it didn't make sense to parse it out any further than that, for it to go to any special use place other than just the general budgets for the agencies that have to deal with gun crime in Cook County, which include the Office of the Chief Judge, who presides over all gun cases, the State's Attorney's Office, which has to prosecute them, the Public Defender's Office, which has to defend those cases, and the Cook County Sheriff's Office, which has to house all the people that are charged.
Well, the laws are passed for public safety,
Yes.
but then if it's in the general fund, how does that happen?
I don't understand your question. Your Honor.
If it all goes to the general fund,
Okay, I was back.
how does that go to public safety?
No, but it nevertheless ends up in the coffers of the agencies that
Ends
deal
up
with
in the
gun
pockets of the governments.
It goes into their general budget.
Right.
If Your Honor's asking what happens
Which
to
the
them after
government
they get
will
there,
use
are they
to put
earmarked or
mostly
for
law-abiding
particular
gun
purpose?
owners
No,
in
they're
prison.
not. They're spent as part of the
Thanks for that.
general funds to that agency. So, Your Honor, getting back to the two-prong tests, first, the courts must ask whether the law imposes a burden on
Here.
conduct falling within the Second Amendment guarantee. If no, that is the end of the inquiry and the law stands. But if there then the second step involves evaluating the strength of the government's justification for the restriction. It's a sliding scale based on the nature of the law. A severe burden would call for strict scrutiny. A law which is less restrictive, like the law that's at issue here, would call for intermediate scrutiny. As I said before, here, Your Honors need not get to step two because the taxes at issue fall safely
Don't
into
get to step two because
Heller's safe
we don't
harbor
want you to
provision.
actually have to follow any kind of
nevertheless,
constitutional restraints
If Your
on
Honors
government.
were to, we would say that intermediate scrutiny is appropriate. Again, the law at issue is de minimis, and the appellate court noted that plaintiff pled no facts to support their conclusion that the taxes restrict or prevent ownership, and found the taxes to be akin to sales taxes and not prohibitive or exclusionary. Your Honors can take judicial notice of the fact that every year since the tax has been implemented, it has drawn in on average $1.1 million. In 2020, amidst the COVID pandemic and widespread joblessness, the tax revenues that we took in spiked to $1.8 million.
Yeah, that
So
was
it's
because all
hard
them
to argue
stimulus
that the
checks and
taxes
people
had
actually
any
being
kind
able
of
to
a
afford
prohibitive
some
or
guns and ammo
exclusionary
at the time.
effect on people
Funny how
asserting
that
their
worked.
rights to go out and buy firearms or buy ammunition.
It's like that meme.
In
What
fact,
what
the appellate
caliber
court
do you
found
want
that
your
plaintiffs
stimulus
could not
check in?
identify any authority even for the premise that taxes imposed a burden on conduct falling within the scope of the Second Amendment guarantee. And again, before you today, they don't offer any new case law or reasoning that would move the needle there. And to address plaintiff's point about a lack of a historical record to show that firearms haven't been tax-free, that's really not the case. There have always been taxes to which firearms have been subject. The National Firearms Act, enacted in
Again, let's
1934,
go all the way
imposed a
back to
$200
the
tax on certain
taxing
firearms.
scheme.
It was upheld by the Supreme Court in Sinzinski v. U.S. They found the $200 tax to be a constitutional exercise of Congress's taxing power. Nobody has challenged this law post-Heller. And I would note that
People
it's
have
8 times
challenged.
the amount of the
The courts have
$25
just
tax that's at
either
issue in this case.
said they don't have any
Watson v.
standing or
Seattle,
flat out shot
which
it
is
down.
the other
It's
example
never been
that
examined.
plaintiff mentioned. In the post-Heller era, Washington Supreme Court upheld that tax, which is nearly identical to the tax we're talking about here today against a preemption challenge. While there wasn't a Second Amendment analysis in that case, the fact that there wasn't a Second Amendment analysis is what's instructive for our purposes. It implies that the tax was considered to be safe from constitutional infringements in the post-Heller era. For all these reasons, the county taxes do not burden the right, and this court doesn't need to get to the second prong of the analysis. But if the court disagrees and believes that the taxes do touch on the Second Amendment guarantee, the county's justification for the ordinance is strong, and any encroachment on the right is minimal. Remember again that in Kwong v. Bloomberg,
Any
the
encroachment
Second
on the
Circuit
right is
upheld
an
a
infringement
$340 gun licensing
and
fee
shouldn't stand.
under intermediate scrutineal
Hence
analysis.
that whole
That's
shall not.
that's what 13 times the amount of the tax
Shall
at
not.
issue here. Also, intermediate scrutiny is proper because, as I mentioned in my introduction, it conforms to the Seventh Circuit review of other laws that have imposed much greater restrictions on the right.
And we know the Seventh Circuit is so good on the Second
Seventh Circuit
Amendment, right?
applied intermediate scrutiny to Illinois' Firearm Concealed Carry Act scheme. In U.S. v. Scoyne, the Seventh Circuit applied intermediate
See, how's
scrutiny
it
to a
going,
law
brother?
barring possession of firearms by people convicted of domestic violence misdemeanors. In US v. Redwood, the Northern District applied intermediate scrutiny to a blanket ban on firearm possession within 1,000 feet of the school. And most recently, in People v. Chiras, this court applied intermediate scrutiny to strike down a criminal law that imposed a categorical prohibition. So despite this robust and binding case law, plaintiff instead resorts to legal tests that have been imported from unrelated fundamental rights doctrines to argue for strict scrutiny, and argues that, but we would position that this is error. It ignores the framework that this circuit has set in Ezel 1 and 2, and it's the law of the land, and it says that intermediate scrutiny applies. Again, the county taxes are so closely tied to their public safety objective that they survive any level of
There is no
scrutiny,
public
and all
safety
these funds
exception
are directed
written
to the
in
Public Safety Fund, which in
the
turn
state
supports
constitution for
criminal
them
justice agencies
or
that
in
are
the
tasked
federal
with
second.
combating gun violence, and they're a de minimis burden. To get around the appellate court's proper holding, plaintiffs urge you to adopt these unrelated doctrines from other rights, and makes mention that the appellate court erred because they ignored these cases.
See, she
But the
does not
truth
believe
is
the
that
Second Amendment is a
ignoring
fundamental
cases
right.
that are irrelevant is never error. While all fundamental rights are co-equal, they are not the same and they're not dealt with the same. Each fundamental right has its own distinct body of case law that has been developed over our 200 years of American jurisprudence. And the Second Amendment is unique from the other fundamental rights. It is not a second-class right, but it's an entirely different right because it
It's
was
the only
expressly
right
limited by our
in the
Supreme Court
text
in
of the
Heller.
right
The Supreme
says
Court
it
was clear
shall
again that the
not
right is
be
not unlimited,
infringed.
and that it was not intended to cast doubt on longstanding limitations on the acquisition, the commercial sale of firearms. In this way, the courts have tailored the Second Amendment framework to accommodate the
Damn,
right
I
to
don't
bear
blame you,
arms
Z.
while still allowing local governments the ability to address public safety concerns. So while the courts draw inspiration from the jurisprudence of other rights, plaintiff is basically asking you to cherry pick cases that are favorable from one fundamental right to another. And it must not be allowed.
I believe he
Your Honors,
comes
I see that
back
my
up
time has
after
expired.
she's
May I
done. I
please
think
conclude?
he got the
You until the
rebuttal
red
from
light
this one.
goes on.
Excellent, thank you. So for the reasons that have been elaborated in our brief, we ask that this court uphold the ruling of the appellate court in its entirety, finding that Maxon Shooter Supplies has no standing in this case. There's no uniformity clause issue. The Cook County firearms sales taxes are not preempted by the FOID Act or by the Firearm Concealed Carry Act.
No, not in
And
this
that the
one.
constitutional
I forget the dude's
the
name.
constitutional
This one wasn't
nature
mine.
of this law is not in question, as they withstand scrutiny under the Second Amendment and the Illinois Constitution and are proper exercises of home rule taxing authority. Thank you for your time today. This issue is very important to the taxpayers of Cook County, who have to shoulder the extensive burden, fiscally and otherwise,
Again,
brought upon
let's
the
go
county
with
by
emotional
criminals.
arguments. Let's stay away from any kind of constitutional analysis.
Mr. Patterson?
Might have to go back through and find
Yes, thank
the
you, Your
written
Honors.
opinion in this, but the state, of course,
Although
upheld this
the
shit,
county denies it,
and this
the
federal court
argument
upheld it.
you just heard confirms that in order to uphold the Court of Appeals in this case, you have to find that the Second Amendment is a second-class right. Supposing counsel argued that different constitutional rights have different tests, different standards.
Yeah, this was back right in the
about
middle of
around
COVID.
them. But there is one thing
kind of middle
that
start
unites
somewhere around
all of them to date. As we mentioned, the right to freedom of the press, freedom of religion, to vote, to marry, to travel, to access the courts. Taxes on the exercise of those rights that single them out for special taxation are unconstitutional across all of those constitutional rights. The opposing counsel has not pointed to a single case.
Damn, Mike, I'm sorry for that,
any
brother.
constitutional context where singling out the exercise of a fundamental right has been upheld. This would be the first. In the briefing, they mentioned interstate commerce and the right to travel, but the cases are clear that generally applicable laws that incidentally burden those activities are okay. But if you single them out they're unconstitutional.
You're talking about
So
a
that,
Vandermine's case?
is the principle.
We listened
that
to
is
the
at
audio
stake
the other
in
day.
this
I couldn't
case.
find video of it, but we listened to the
And
audio.
opposing counsel also criticizes us for not citing to other cases in this area. That is because this is the first case.
Yeah, dude, that stuff's
No
rough,
other
Mike.
court has faced a Second Amendment challenge to a tax, a special tax on Second Amendment rights. And that is because Cook County is one of only 2 jurisdictions in the history of this nation to attempt this. The Seattle case, for whatever reason, the plaintiffs in that case didn't raise a Second Amendment claim. I don't know why, but that's why that case didn't address the
I'm
Second
pretty
Amendment
sure
case.
if I went and looked in the Seattle
Council discussed
case,
the National Firearms
they
Act.
tried to
That was
fight
a
it on the
tax
grounds which they
on
should have, but it
sawed-off
was just
shotguns
unconstitutional by the
and
state.
machine guns. And the Supreme Court in Heller said that act may have been struck down if those firearms were protected by the Second Amendment, but those arms are outside the Second
Another
Amendment.
shitty
This is the
part of
reason
Heller.
why that tax was allowed to remain in place and why it's no precedent for the tax at issue here. Counsel also says that intermediate scrutiny needs to apply. This court has not uniformly applied intermediate scrutiny in Second Amendment cases. In Aguilar, it categorically struck down.
No, it's not the same
open
dude, I
carry
don't think.
Firearms in
I'd
public.
have to go back and
In
look,
Webb,
actually.
it categorically struck down the ban on carrying stun guns.
Did either one of those cases specifically adopt a strict scrutiny standard?
No, they didn't apply any scrutiny at all. They said after the first step, this is just categorically illegitimate and did not apply any sort of scrutiny, similar to the Heller case.
I don't
And,
remember the guy's face
But
in the
other
other case.
cases that this court has dealt with in Second Amendment issues, the court has consistently, when discussing what level of scrutiny is appropriate, has consistently used an intermediate standard, has it not?
When it has applied a scrutiny analysis,
And
but it
then
has
they-
not applied it in all cases, and it has said it's a sliding scale. And it has looked to other constitutional rights that have a similar, in the First Amendment. Some
I know,
laws are subject
Patriot,
to
yeah.
intermediate scrutiny, some laws are subject to strict scrutiny. I would submit, in the Second Amendment's no different. And I would submit the binding precedent is Boynton, which followed Minneapolis Star and Tribune, which was in a different constitutional right. It was the right to freedom of the press. Boynton was freedom to marry. And the court said, under Minneapolis Star and Tribune, because this is a tax on a fundamental
We're talking
right,
about
we must apply strict scrutiny.
free
like the
speech
Supreme
and
Court
the
did
Second Amendment here.
in
just a
Minneapolis
second
Star and
after we
Tribune.
get done with this.
But ultimately, nothing turns on that distinction because even under intermediate
And
scrutiny,
then we're going to go into people
you
saves
can't
lives
burden
too.
substantially more protected
Was the
conduct
challenge after this.
than you need to achieve your objectives. And here the objective is raising revenue. And there is a clear alternative. Get the money from a generally applicable tax like every other jurisdiction in the country except for Seattle does. So even under intermediate scrutiny, there is no way that this law can succeed. It's not even clear that this is a net benefit financially to Cook County because this extra tax on firearms and ammunition directs sales outside of the county to people trying to avoid the taxes. So then they lose the sales tax revenue from those sales. The
Good
evidence
deal,
in the record
Warsaw.
indicates that from June to December 2016, Maxon's revenue
Hell
from
yeah.
ammunition sales was down $51,000, which was the first 7 months that the ammunition tax was in effect. So they've not attempted to conduct any sort of net analysis of the money they're losing by people going to neighboring counties where gun stores, as the record also indicates, are saying, come buy from us and don't pay the quote unquote Crook County tax. So even under its own objective, it's not clear that this tax meets that objective. There's an argument that the burden here is somehow de minimis, but a $25 tax is in no circumstance de minimis. Even the ammunition tax, the evidence in the record that the sale that one of the Gun Save Life members, the purchase that they were involved in, it was about at 12.5% on the sale of that ammunition. So that is not a de minimis tax. And again, as I stated in the opening, it's much more than taxes that have been struck down. And going back again over 200 years to McCullough, the Supreme Court has said when we're dealing with taxes that are infringed upon in an improper area, and that it was a state attempting to tax the federal government, its operations, we don't analyze the extent of the burden. It is the tax itself, the extension of the taxing power to that area, that is the burden, and that's the substantial burden, and that is the line in the sand that the courts have drawn and said that cannot be passed. So for all those reasons, Your Honors, we submit that this tax must be struck down. I'm happy to field.
Now, the next one I couldn't find video on, so again, we'll just be listening to the audio
No
of it.
additional questions, counsel. Thank you.
Okay, thank you very much.
So,
Case number 126014, Gun Save Life Inc. versus Zara Ali et al. Will be taken under advisement as a
me
Mr. Patterson, Ms. Jimenez,
snag
we thank you for
that.
your arguments today.
all right, so let me get this. You guys let me know. Make sure the audio on this is coming through. I think the audio on this one.
Our first case this morning is case number 419-0334,
Oops.
Gun Save Life versus Kwame Raoul. And for the appellant, we have Mr. Patterson.
Yeah, that's
And
kind
for
of
the
as high as
appellee,
I can
Ms.
get,
Humbert.
guys. So it's
You may
just
proceed,
I'm
counsel.
actually going to mute kind of stay away on this one a little bit. Yeah, my
Pete Patterson for the plaintiff appellant, Gun Save Life. We are here today asking the court to reverse the trial court's refusal to enjoin Illinois' outlier law that requires law-abiding citizens to obtain a license to possess a firearm even within their own home. There are various reasons why this law is unconstitutional, as we've explained in our brief, but at the outset, I'd like to focus particularly on one, and that is that Illinois—
Counsel, let me ask you this.
Yeah.
Ultimately, what are you asking this court to do?
We're asking you to order the district court to enter a preliminary injunction enjoining the state of Illinois from enforcing its requirement that citizens have a FOID card to possess a firearm in the home. We've asked for an injunction to, enjoy the FOID Act generally. So to possess a firearm in the home, to possess it, to have one to purchase a firearm, to go to a firing range. What we're not asking the court to do anything to affect Illinois' laws on the concealed carry of firearms. So we're only talking about firearms within the home here, and obtaining a firearm within the home, which is obviously essential to exercising that right, training with a firearm as Ezel held.
And so you're not asking us to
Wait a minute, I'll be back.
declare the statute unconstitutional?
Well, yes, we're asking you to declare that statute unconstitutional. That's the relief we're seeking in the law.
Doesn't that take it too far? I mean, you're appealing the denial of a request for an injunction. Is it really our place to declare the statute unconstitutional?
No, that's precisely right, Your Honor. We're asking you to rule that it's unconstitutional, or that we are likely to show that it's unconstitutional, and therefore enter a injunction enjoining its enforcement during the pendency of this appeal.
Looking at whether or not the trial court should have granted the injunction, we obviously have to consider whether or not you're likely to proceed on the merits.
Yes.
That is different than necessarily ordering or finding that you win, that it is unconstitutional. Would you agree?
Yes. So we're not asking you to find that we win. We're asking you to find that we're likely to win and that we satisfy the other preliminary injunction factors, and therefore that the trial court should have and now must enter a preliminary injunction.
But if you win the injunctive relief that you requested, then haven't you essentially won the case on the merits?
No, we haven't, because if we were ultimately to lose after a trial and the law was no longer enjoined, then our clients would, and all the members of Gun Save Life would need to have a FOID card to possess a firearm. So to be clear here, we have some illustrative members that we discussed in the complaint and that also attached affidavits to the PI motion. But we're not challenging any particular application of the FOID card requirement. We're challenging it on its face, that facially it's unconstitutional to require a person to possess a license to possess a firearm in the home. And as I was saying at the outset, I'd like to focus on one aspect of that.
Yeah, brother Mike, you just got to keep on trucking. And
Succeed in
that's
showing
hard.
It's unconstitutional, and therefore that an injunction should be entered, just as in the Ezel case in the Seventh Circuit that's been cited in the briefing to this court. There's an Ezel 1 and an Ezel 2. Ezel 1 was on a PI motion, and the Seventh Circuit reversed the district court's refusal to preliminarily enjoin Chicago's requirement that gun ranges could not or locate in the city of Chicago. So it was a similar dynamic here, where we're asking that you find that we're likely to succeed on the merits, and therefore that to foreclose the irreparable harm that we're suffering from being subject to an unconstitutional requirement, that law be enjoined during the pendency of this lawsuit.
Purpose of injunctive relief, though, also includes keeping things on a status quo, correct?
Well, I think what a lot of the cases say.
First of all, the answer to that question is either yes or no. Then we'll go on to the next one.
Right. Well, that is one purpose of injunctive relief.
What do you see as the status quo?
I see the status quo. A lot of cases discuss it as the last uncontested status. So the last uncontested status here would be that we're not required to possess a license to possess a firearm. But even there's no rule against a preliminary injunction that does not enforce the status quo. The requirements are, you show you're likely to succeed on the merits. You have no relief at law. You're going to suffer irreparable harm if the law is not enjoined. The balance of hardships tips in your favor.
Yeah, think about it. There was a lady arrested in her
It's
home
not a requirement that you maintain the status quo. And again, in the Ezel case,
for having a shotgun. Wasn't committing crimes with it. Wasn't threatening anybody.
Books that said in order to get a handgun, to get a gun permit, I believe
She's had a shotgun without the government's permission.
do some training, and then it said ranges couldn't be in the city, and that law was enjoined on appeal, on a preliminary injunction appeal. So to proceed, so we can discuss why we're likely to succeed on the merits, if the court is open to that. We've got
The court will actually let him make his case.
Before you do that,
Sure.
this is a teachable moment
Yeah.
here at the law school, so I want to elaborate a little bit. You said that you're making a facial challenge
Yes.
to the statute.
Yes.
And so basically, you're saying there are no circumstances under which this statute is constitutional. It's not based on application in one individual situation, but you're saying.
All right, Mike, take it easy, brother. Be careful out there.
Exactly right. And so the Illinois Supreme Court has discussed that distinction. For example, in the Burns case, which had to do with carrying a firearm in public, there was a felon that was convicted, and the state argued that, well, this is constitutional as applied to him because he's a felon. And the court said, no, that's not how it works. That's not an element of the law that doesn't say on its face that you have to be a felon. The law that said you can't carry firearms in public is facially unconstitutional. Therefore, you can't apply it to him or to anyone else. And that's the argument that we're making here.
In other words, you could charge him with being a felon in possession, but you couldn't charge him with carrying in public.
That's the lowest level of scrutiny that potentially could apply, because under Heller, the court said rational basis review is out. And the state can't satisfy intermediate scrutiny for two related reasons. First, they can't carry their burden to submit actual evidence that this law advances the public safety interests that they say it will advance.
I don't know, Warsaw.
And relatedly, under the Supreme Court's decision in McCullen, which made this very clear, under any intermediate scrutiny, you have to show not only that the law will advance some government interest, but also that it's narrowly tailored to that interest. And in the intermediate scrutiny context, that doesn't mean it's the least restrictive alternative, but it means that it's not substantially broader than it needs to be. And the state has to show that it actually tried to other approaches that didn't work, or give good reasons why those other approaches wouldn't work.
What level of scrutiny do you say applies?
Well, we have two. So we say first that Heller's analysis should apply, which is that, you do a historical and traditional analysis, and you determine whether it's consonant with the history of the right to keep and bear arms. And if the answer is no, it's unconstitutional without any scrutiny analysis at all. That's what the Illinois Supreme Court did in Aguilar and Webb. It's what the Seventh Circuit did in the Moore versus Madigan case. So we submit that, our first argument is that's
you don't have to. And these judges want to stay on the scrutiny shit just so that they can make the law up as they go.
Person have a license to possess a firearm in the home. Even today, there's only one other state in the nation that requires this. So there's absolutely no history to speak of this sort. It's an extreme outlier type of law in the history of firearm regulation. And secondly, we argue if a level of scrutiny is going to apply, it's got to be the strictest level of scrutiny possible. Under the Shirez case, I don't know if I'm pronouncing that right, but the Illinois Supreme Court said you look at the breadth of the law, the number of people that it covers, and then you look at the nature of the law, how close it gets to the core of the Second Amendment. And here, we've got a law that applies to the entire population of the state of Illinois, and it reaches into the home where the Supreme Court said Second Amendment rights are the most acute. It's the core of the right. So if the strictest possible scrutiny should apply, and the state hasn't even argued that the law satisfies that level of scrutiny. So
there's been a few like that, Warsaw.
But even under intermediate scrutiny, under McCullen, as I said, the Supreme Court
it's absolutely insane.
to some broad prophylactic regime. There, it was a 35-foot buffer zone around the entrance to abortion clinics without trying other things first. And the court specifically said, if you've got some sort of outlier law that is not a law that is typical, that other states have, you face a headwind. That's kind of some evidence that you don't really need to do what you're trying to do. And here, there are a multitude of other avenues that Illinois could pursue or that already are on the books that
you
they can
mentioned
enforce.
that there are, I think in your brief, you said a variety of mechanisms
Yes.
to enforce, such as.
Okay, yes, I'll list at least 4. So one, we've got at federal law currently, in order to buy a firearm from a licensed gun dealer, you have to submit to a background check. And so that background check is going to flag if you're a felon, if you're mentally ill.
And under a federal law, you can do person-to-person transfers.
Now it responds that
without a background check.
It may not cover all the transactions you want it to cover. Well, then the solution to that would be to have a state law that extends the background.
Now, there are bills in Congress right now to basically do a national FOID card.
Second,
by the implication of your brief was
Yeah.
there are mechanisms currently in place.
Yes. And one of those mechanisms currently in place is that to buy a firearm from a licensed gun dealer, you have to submit to a background check.
What's currently in place in terms of regulating the sale of ammunition?
I don't believe there are regulations currently
Nothing.
in place, at least not at the federal level. I'm not positive at the state level, but I believe it's the FOID requirement that is the regulation that's in place. But just to be clear, in the McCullen case, for example, it's not what regulations are in place. It's what regulations are there that are in place or could be put in place that are narrower, less burdensome than the alternative that the state has.
Your word. Your brief says a variety of mechanisms to enforce the laws are in place.
Yeah.
Dude, you don't have to take him in his word. He gave you the text of the federal statutes, you fucking
The second
numbnuts.
one that's in place is that there are currently laws against felons and the mentally ill possessing firearms. Those laws can be enforced vigorously. Most of the disqualifying conditions involve some sort of contact with law enforcement or other public institutions. For example, if you're convicted of a felony, that's obviously going to involve contact with the law enforcement system. So when that conviction
Yeah,
comes
Warsaw.
down, there can be processes in place to ensure that a person doesn't
But are
possess
there currently
firearms. There are
processes in
currently
place?
processes in place that require that notification be sent to the state that a person has suffered one of these conditions. So those are 2 things that are in place. They can enforce the existing laws against prohibited possessors. There's background checks. And then there's also, as I said at the outset, there are concealed carry laws in place. So this is only about firearms in the home. So even if we were to prevail, the minute someone takes the firearm outside the home,
And see,
in a public
The minute they even started talking about that, this case should have been done. It should have been, no, we can't do that.
And now I mentioned 4, but I
If Heller was such good fucking law, it should have shut them down, or McDonald. Before then, Heller 1, Heller 2, McDonald should have shut all this down.
Neighbors, associates, people that own firearms could tell the authorities, hey, there's something happening with this person. I think it's a problem that he's got a firearm. I think it's going to be a danger. And then after some sort of procedure goes in place where that could be tested, that person could be disarmed. And several states have
So those could be
tried
abused,
those sorts
just
of
like
laws.
orders of protection and stalking, no contact orders.
Yeah, something of that nature. But they're called, firearm protective orders or something like that, where if there's a finding that a person poses some threat to public safety, they can have their firearms taken away for a time. And just to be clear, as in McCullen, it notes, we're not necessarily endorsing the constitutionality of all these options, but we're not challenging them here. In the case there said, well, even, nonetheless, you still consider them as potential alternatives to the more broad law that is in place.
Opposing counsel indicates that you have basically switched gears, that you allege one thing in your complaint, basically primarily the issue of the $10 renewal fee, and that now you're broadening your scope and
it's been way worse than that for a long time, man.
Does your complaint raise the issues that you raised in your motion?
Yes, it very clearly does, and that can be seen in a few places. First, in paragraph 23, the count of the complaint, the Second Amendment count, starts around paragraph 21 or so. In paragraph 23, we say that the FOID Act places an unconstitutional tax on the exercise of this right. And then in paragraph 24, we say the FOID Act is also unconstitutional on its face because it directly burdens the exercise of Second Amendment rights. So we're raising two alternative theories under our Second Amendment claim. And then that can be shown, moreover, as we go on in that count, we discuss some of the problems with this law. And one of them was a situation that the Brown court, which was in a criminal case, held the FOID Act unconstitutional, and the case is currently before the Illinois Supreme Court, said, well, the way constructive possession has been interpreted, it means that it's impossible, for example, when you're taking a shower, if you do that and you have constructive possession of a firearm and you don't have your FOID card on you, you're in violation of the law. So we mentioned that in the count. That has nothing to do with the fees. Obviously, it's going to the possession requirement. Similarly, the one named member that we mentioned in the complaint, Mr. Meyer, the problems that he had nothing to do with the fees. He was revoked a FOID card because of a false conviction that had, the uncontradicted evidence in the records that it never took place. He was forced to return his firearm. Again, that has nothing to do.
This is a dude who actually didn't commit a crime,
in the complaint.
but you'll hear how the state argues it in a minute.
Arguing the preliminary injunction, did he squarely address the constitutionality of the statute?
Yes, in fact, that was our primary argument. And then we said in the alternative, I think they say in their brief, well, it's not until page 9 of page 16 that they get to the fees issue, but instead they switch. So that's another indication that we filed the PI motion very shortly after we filed the complaint, leading with the argument that it's facially unconstitutional. So, clearly we had intended and understood the complaint to encompass both of those things, which is shown by our prayer for relief, which asks for the FOID Act to be struck down categorically, not just for an injunction against the imposition of the fees. So for all those reasons, we think it's pretty clear that we challenge more broadly in the complaint. And what is more, Illinois is a fact pleading jurisdiction, not a law pleading jurisdiction. So even if we had mentioned the wrong legal theory or not included a certain legal theory, we have the Second Amendment.
86 was the GCA, I think. NFA was 34, remember?
Bring that issue to this court's attention. And in terms of, again, under intermediate scrutiny, Ezel is very clear. Ezel 2 says that lawyers' talk is not sufficient. We need some sort of actual and reliable evidence. Here we don't have citation to a single study. We don't have a single affidavit. We don't have any explanation for why both the existing laws and the laws that Illinois could enact would not advance these interests to the same or substantially the same extent as putting this broad prophylactic sort of law on top of it, requiring law-abiding citizens. It's not only that they have to obtain the FOID card before they possess a firearm, they have to maintain it. Every time you have your firearm in your possession, you have to have your FOID card in your possession. If you move, you have to update your address. If it gets lost, you have to get a new one. If it wears out, you have to get a new one.
And if it gets lost, you can't have your gun on you until you get that other FOID card.
That you have a firearm. And
It's insanity.
Illinois has absolutely no evidence that this advances public safety to any marginal degree. So for that reason, we submit we're likely to succeed on the unconstitutionality of that requirement. And switching briefly to the fees, I'll just focus on one point there, and that is that, the other side relies on the Cox case from the United States Supreme Court. And that case held that, a state could have a licensing regime with associated fees for public parades. But the court was very clear in that case that the reason it could do that is because this is a time, place, and manner restriction.
And we're gonna talk about that before we hit the next topic too.
Public street, namely that you can't have two parades going on at the same time. So this actually is promoting speech by facilitating the ability of people to have parades. And the Supreme Court has been very clear in subsequent cases that that's what the Cox rationale is limited to, is where you have some sort of this rivalrous exercise of a constitutional right, and you need some sort of regulation in place to regulate that. So in the Murdoch case and the Follett cases, which came after Cox, they struck down laws that didn't fit within that regime. And then in the Forsyth case, the Supreme Court said very clearly, government, in order to regulate competing uses of public forums, may impose a permit requirement on those wishing to hold a march, parade, or rally. That rationale does not cover the possession of a firearm in the home. That's not a time, place, and manner restriction. That's, you can't possess a firearm at any time, at any place, in any manner without a FOID card. And the Supreme Court has struck down requirements of that nature rather than following the Cox line of cases. And then briefly moving on to equal protection, we rely on the Harper case, as your honors know, which struck down a $1.50 poll tax, saying that the payment or non-payment of this poll tax has no reasonable relationship to whether you should be able to vote or not. Submit the same reasoning applies in this context. Whether you pay the 4 fees or not should have no bearing on whether you're able to possess a firearm. And just finally, because
Counsel,
sure.
I'm sorry, you're out of time.
Okay.
You will have additional time on rebuttal, though, if you desire. Thank you. Ms. Hunger?
All right, so here we go with the state's lawyer coming up. And listen to this hoe.
Good morning, and may it please the court. Deputy Solicitor General Sarah.
Yeah, I got you, Warsaw. I knew where you were going.
The plaintiff is here today, as has already been noted, asking this court to grant it extraordinary and unprecedented relief. It is asking this court on a preliminary injunction record and under the theory of associational standing to enjoin the entirety of the state's firearm licensing scheme. Now, putting all of those threshold questions to one side, it's important to note that the FOID Act is constitutional. It is a long-standing regulation ensuring that dangerous persons, such as felons and the mentally ill, do not acquire firearms.
Yeah, go to downtown Chicago and tell me that.
The FOID Act itself has been in effect for more than 50 years. It actually predates the right to bear arms in the Illinois Constitution.
If we're doing the historic, I'm sorry. If we're doing
Let me hold that for just 1 second. So again, we get back to the state arguing that since this restriction, this infringement has lasted this long, then it's perfectly okay. No, just because an infringement has lasted a really long time doesn't make it any better. It makes it a really shitty infringement that should have gone away a long time ago. But again, these judges and the state, they will do any mental gymnastics they have to. They will bend over, put their heads so far up their ass, they are basically a giant walking colon to hold on to their power.
Well, a couple of points. They have two different theories here. They're relying both on the Second Amendment and the Illinois Constitution. So I would submit for all of the.
That's because the FOID card is illegal on both counts.
That predates that Constitution must be deemed longstanding. When you're looking at what we discussed both in the brief, and I apologize for any confusion on that front, but they are raising both of those. But
you mentioned confusion.
Yes.
Let me ask you a question. Page 17 of your brief, you said, quote, all of the causes of action also focused on the challenge fee. There were no causes of action alleging that the
Correct.
All right. Page 5 of the complaint, after they outline not only the key, but all of the aspects of the Floyd Act requirements, they then put in bold type, the Floyd Act infringes on the rights of Gun Save Life members. They then talk about being subject to the Floyd Act restrictions, affecting their right to possess firearms. Neither member that they identified lost their Floyd card as a result of the fee. Count 1, paragraph 24, count 2, paragraph 29, count 3, paragraph 31, count 4, paragraph 37, all allege the same thing. The Floyd Act is also unconstitutional on its face because it directly burdens the exercise of Second Amendment rights. Count 1, paragraph 25, count 2, paragraph 30, count 3, paragraph 36, count 4, paragraph 42. For these
Yeah, that's another good point,
Floyd
boy.
Act is invalid and cannot constitutionally be applied to members of GSL or anyone else in the state. In their prayer for relief, they ask for a declaratory judgment that the act, not the fee, violates the Second and 14th Amendments, and that you be enjoined from enforcing the act. Nowhere in the complaint do they seek relief only from the tax. I'm trying to figure out where in the world you got the idea they weren't talking about the Floyd Act being
Because they don't care.
Well, I would point you to the next sentence in paragraph 24. They say the Floyd Act is also unconstitutional, as you read. And then the very next sentence says ownership licenses with attendant fees have no basis in the history and tradition of firearm regulation in the nation. Every time they define the license, they define it with the attendant fee. But in any event, I'm here today able
Again,
these to speak to the constitutionality of the Floyd Act. You know, when you take everything together, our point was it's a preliminary injunction motion, actually a TRO motion that they brought, moving very quickly through the circuit court. You have a complaint that is ambiguous about what exactly they are seeking, and you have two members that don't completely line up with either theory in terms of standing. When you look at that all together, this is not the case to
you have to
down
be
or enjoin the entirety of the
a
state
moron or completely intellectually dishonest
merits, going back to the question of this, whether
to
this is
believe the
only
state's
zoning.
case.
If you look at the time, as Heller said, of 1791, if that's the time period that we're looking at, Heller itself said it's a long-standing regulation to be able to ban felons and the mentally ill and other dangerous persons from possessing or acquiring firearms. Now, we also know
because it had a basis of pre-existing Second Amendment.
Right, but what we also know that if a state can set those substantive requirements, a state can also have a system to enforce those requirements. The Seventh Circuit has said that.
Yeah, I've seen that before, Warsaw.
For example,
It's crazy.
and this court does follow, as the Illinois Supreme Court has indicated, this court does follow decisions of the Seventh Circuit. So you're not necessarily looking at, well, was this specific licensing
And again, we know the Seventh Circuit is absolute shit on the Constitution.
requirements, which counsel today has said they're not challenging. There are no challenges to those substantive requirements. And if a state is able to have those substantive requirements, it has to have a way to monitor those individuals and to have a scheme to make sure that it's being followed.
How would the other 48 states manage to work this out?
Well, so that is another point that I would like to bring up. There are actually about 15 states that have similar requirements.
Sam, what's up, brother man?
Not exactly the same.
Blanket restrictions on the possession or ownership of firearms, as opposed to restricting your right to carry in a certain way, restricting certain types of firearms, restricting handguns, concealed firearms. You're saying that there are 15 other states that have blanket restrictions on the ownership, possession, purchase, or sale of firearms.
Yes, I'm happy to go through them. So if you start with the 3 states that have license to possess a firearm, that's Illinois, Massachusetts, and New York. There are 10 states for a permit to purchase, as you said, Your Honor said, is included in the description. Point of sale, and obviously one needs to purchase the firearm in order to possess it. Those are Connecticut, Hawaii,
No, I could build it.
Maryland, Michigan, Nebraska, New Jersey, North Carolina, Rhode Island, Massachusetts. Massachusetts does both.
We know Massachusetts and Illinois are the 2 states that have
Exactly, right. And so the,
Other than
the
that-
other, the others are the permit to purchase, but not the permit to own. But as we know, you have to acquire the firearm in some manner.
You didn't have to buy it.
But that's a permit to purchase
If you
from
acquired in
a
that state,
licensed
then
dealer,
yes,
not
you
from
would be subject
an
to
individual sale.
um, then no, you would be able to possess it in that state, subject to the state's other laws.
And you don't have to reapply.
You would have to, no, you do not have to reapply, but if you go to
So it's a
purchase a
one-time.
new firearm,
Right.
yes, it's one time. DC has a firearm registration law, so if you did move to DC with your firearm, you would have to register it. And there are 2 states, California and Washington, that require firearm safety certificates before you can purchase a firearm. So that's similar, I suppose, to the 10 that I enumerated before. The point of sale. But
Yeah, same old same,
the
Sam.
of this analysis is not looking at either when you're looking historically or currently, whether or not there is an exact
I may not get time to today, Warsaw, because there's something else I want to hit on for a little bit. And then I'm going to have to bounce.
And that are reasonable, as shown by what I just identified here. And Illinois has selected one that other states have selected that has been in place since 1967. And there are analogs.
What other states require point cards like Illinois?
That would be Massachusetts and New York would be the 2. New York only relates to handguns, I will note.
And guess who controls all of that?
Massachusetts is the only one that has an exact analog, but that is not required in order to find something constitutional, as numerous courts.
No, to find something constitutional, you have to look at the text of the Constitution,
is allowed to choose among different
compare the two, and if it doesn't match, it's unconstitutional. It's that fucking easy.
Is asking it.
Well, no, but if this is such a terrible problem, I'm trying to figure out why is it that only 2 states seem to need to have this blanket restriction?
I suppose, other states have found that for their particular problems, the permit to purchase does satisfy that. They may also have other regulations that Illinois does not have. For example, other states have bans on large capacity magazines. They have bans on assault rifles. They have all sorts of other regulations.
Yeah, Warsaw. And we still got to get that stream together. Now that shot's over, maybe we can get everybody together.
A decision that is constitutional and whether it is reasonable when looking at all other alternatives. I would also
Is there
note
any obligation on the part of the state to find the least restrictive measures possible to ensure the safety and basically the reasons why you're asserting that this statute is constitutional and necessary?
no, that is not required. As I have been stating, under intermediate scrutiny, the question is whether or not it is a substantial relationship between the public policy goal and the regulation at issue. And I would note too, there is plenty of evidence.
So
that
she's
was
right back to
put
interest
forward in
interest
front of a
balancing.
hearing and not on a TRO that shows that licensure systems actually do have incremental benefits that these permit to purchase statutes do not have.
Ms. Unger,
Yes.
I want to ask a question in that regard. Mr. Patterson indicated in his argument that there is no evidence in the record regarding the efficacy of the Floyd law. A, do you agree with that? And B, what relevance is that at the TRO stage?
So there is evidence in the record showing that the General Assembly has made a reasoned judgment. If you look at the logic and the common sense that we have pointed to and the different cases, there's no documentary evidence in the record, for example, expert witnesses or something that you would see at a later stage. I would say this just underscores the extraordinary nature of the relief that they're asking. I mean, this statute has been in effect for over 50 years. And without any type of evidentiary record on a TRO, they are asking this court to enjoin it. I can point to several studies right now that we would submit as this case goes back and a full hearing is held.
Please submit something like that. And then just let someone like John Lott rip it to fucking pieces.
Empirical studies.
Were they admitted at the trial court level on this issue?
They were not. I'm happy to go through them, or I can also move on, whichever the court prefers. But there is substantial empirical evidence on our side. which also explains why all of these other states are requiring licenses to possess or to purchase. I would note that as this court has held, the Illinois Supreme Court, federal courts, though, you need to just show that the General Assembly is picking among reasonable policy alternatives. And they have done that here. It makes sense that if you have a system where someone has to show that they are eligible they have to have a point of contact.
What's the crime rate in big cities in
Point of contact
Illinois these days?
to come forward and show that they satisfy the requirement. That is going to deter some criminals and some mentally unfit individuals from not possessing firearms. And that is all that is needed to show. In our brief, we cite examples of cases where individuals thought that they could get a FOID card or they could get a CCL card. You take a look at their background and they absolutely should not have one. One individual threatened to put his neighbor in a wood chipper and 6 feet underground. That came out
Okay.
in the course of ISP going through and checking to see whether this.
So was he convicted for terroristic threats?
They were not dangerous.
Was he convicted of a crime?
Like this, that person would possess a firearm because they looked at their situation and thought, I can possess a firearm. This is why we have these enforcement systems. It's so that the state police can check and make sure that the public is safe. The plaintiff is not challenging any of the underlying.
Oh yeah, Warsaw. I got to look him up. I've seen a bunch of video, I think, from them. It's hysterical.
And I would note, they're here under associational standing doctrine. They have not pointed to any neighbors showing that they cannot afford the $10 that they cannot.
It doesn't matter whether they can afford it.
It is an affirmative defense in Illinois, and we have raised it. Yes, and we have.
And here we go with the idea of standing, where the court could just blow someone off.
So they have come forward. Only one on appeal. Mr. Meyer was the only one that they mentioned on appeal. No one has come forward to say, this is too burdensome for me to apply for this.
It's your burden.
Yeah, Warsaw, what I'm saying is I think I've seen some videos from them.
Well, you did that in your brief, too. I'm trying to figure out how you do that. Because it's your burden to establish that they don't have standing. It's not enough to say, I'm judged, they don't have standing.
Well, that's within their personal knowledge whether they feel burdened. We have said as an affirmative defense that they have not explained how they feel burdened. It would be very easy for them.
It's simple. You see people that are otherwise law-abiding going to jail
the application process
because of these bullshit-ass cards.
We have no idea why they are here challenging. Well, associational standing, you have to have a member that has suffered an injury in fact. And so we need to know what that injury in fact is. And it's not evident from anything.
There's right to possess a firearm without having to get the state's permission first. Pay a fee for it.
They say that, but for example, Mr. Meyer.
Is there anything?
They say that, but we don't give a shit because I'm the lawyer for the government, so we win.
No. You're saying that's what they're saying.
That's our entire argument.
Not true about the fact that you have to get the state's permission and you have to pay a fee before you can possess a firearm in Illinois.
There's something untrue with respect to Mr. Meyer, and that is he has a misdemeanor crime for domestic violence. That is a federal.
No.
That has nothing.
There is no evidence whatsoever he was convicted under anything like that, you bitch.
The Illinois State Police have said, as counsel has admitted in their brief, the Illinois State Police has said he has a misdemeanor crime of domestic violence. I understand Mr. Meyer disagrees with that.
Well, the record in Chicago disagrees with it too, right?
Thank you, Judge.
Evidence. The Illinois State Police have come forward with another piece of evidence.
Was that submitted to the trial court?
Well, the piece of evidence is that the Illinois State Police said he didn't have a misdemeanor crime of domestic violence based on their review of his file. And that is, I understand.
In other words, someone else probably did, and it name matched, so it stopped this dude.
Illinois State Police believes that,
which is the same way the federal background check system will stop people.
That is
Where?
on the record, but it's uncontested.
It's public record, bitch. You're a lawyer. You could find his arrest documents if he was arrested. You could find his court documents if he went to court, and you could find his conviction documents if he was convicted.
So their position, there are actually another adequate remedy at law for Mr. Meyer, and that is to file a Section 10 petition and challenge that, which I understand that he has done, but that's the remedy for that. And he is in the process of that, as I understand it currently.
The remedy for a claim that an act is unconstitutional is to utilize the provisions of the unconstitutional act in order to gain relief. How do they do that? If as they claim, the act is unconstitutional, you're saying the way that they can get relief is to utilize the conditions of the unconstitutional act in order to get the relief they're seeking. And they're saying, no, wait a minute, we don't want the protections of the FOID Act. We want the FOID Act gone.
Well, those are two separate claims. My point is simply to challenge
Joe Morris, what's up, my brother?
Misdemeanor crime of domestic violence and is therefore federally prohibited from possessing a firearm. Absolutely nothing.
But you can't prove anything about.
State, and he has this federal bar. He cannot possess a firearm. It has nothing to do with Illinois' requirements. There is a remedy for that within the FOID Act, and as I understand it, he is currently going through those channels, and so we will know at some point.
I have to look up the opinion in this case because it's still running through the courts, I believe.
Right. So the elements of associational standing are that in the association.
Matter of fact, while we're thinking about it, let me do.
They don't have to name the member. They have to identify a member who has been harmed, who would satisfy standing on their own behalf. And what I am saying is that there is no member who has come forward with that type of evidence after we raised the affirmative defense. I mean, we raised it right away in the circuit court.
That argument seems circular, though. I mean, the whole premise is that it's unconstitutional to have to pay for the right to possess a weapon in your home. That's the harm, as I understand it. So I don't understand what additional showing you believe they need to make.
Well, Mr. Meyer, for example, it's not the FOID Act that's injuring him. It's a federal prohibitor that's injuring him. So, for example, pointing to a member who has shown that they are being harmed in some way, other than just that they don't like the statute. You know, if there is an actual injuring fact to that member, but regardless of standing and all these other thresholds.
Case text.
You know, what remains is that the plaintiff is here seeking absolutely extraordinary relief. The FOID Act is constitutional, as many state courts have held. In the first district, for example, in the Taylor case, the first
This was 19
requirement under strict scrutiny. You also have Mosley and Henderson. In the federal context, you have Horsley and Barron and Culp too. I mean, the FOID Act has been upheld as constitutional because it is. It's not an outlier law.
I want you to, if you would, address one issue that was asked of Mr. Patterson before you run out of time.
Yes.
I'd like you to have an opportunity to address this. Mr. Patterson was asked in regards to the status quo. And is the status quo, the maintenance of the status quo, a factor that the trial court is to evaluate, is for us to evaluate here? And
this should have been in
this case.
Yes, that is a factor, and the equities would lie with the state. As I've said,
Fourth Circuit, right?
50 years. It's also tightly wound up with many other laws, like the Concealed Carry Act relies heavily on the FOID Act.
Fourth
We actually
District.
do have a red flag law in Illinois here. That depends upon provisions of the FOID Act. If you undo the FOID Act, it's going to create a ripple effect that will affect the entirety of the firearm licensing schemes in Illinois, which is something that the plaintiff does not grapple with. We know that there will be more homicides, more suicides, more guns in the hands of criminals if these licensing
No, you don't.
are lifted. And we simply are asking here today that this court not do that on a preliminary injunction record. This should be fully fleshed out with a hearing and with evidence on both sides. Thank you.
Any rebuttal, Mr. Patterson?
Yes, just briefly, and I'll start with that last point. We do not know that there will be more violence in Illinois if this preliminary injunction is entered. They have submitted no evidence at all showing that.
Seen the 19 opinion, but this was.
In the trial court, they didn't. It doesn't matter that this is a PI.
Are they still hanging on to this one and haven't fucking decided it yet?
PI posture. The court similarly said that you have to have adequate, actual, reliable evidence. They don't have that here. That demonstrates that an injunction should issue. Another thing counsel said was that, well, if felons and the mentally ill can be prohibited from possessing, that means that the state needs to be able to track everyone to determine that they're not felons or mentally ill. But that simply, one does not follow from the other. That would be saying, like in the First Amendment context, because we can ban libel and slander, we have to have everyone get a license before they can.
No, that's Barrett v. Raoul.
What they're saying isn't libelous or slanderous. Maybe we think that would be a good idea, but it surely would be unconstitutional. That's just not the way that we regulate constitutional rights in this country, and that's why there's a dearth of historical or even contemporary support for this type of law, as counsel confirmed. It's only Illinois and Massachusetts. And finally, on associational standing, the state fails, I think, to grapple with what we're complaining about here. We're not complaining about the fact that, Mr. Meyer was disarmed and now he has to go through some sort of process. We're complaining about the fact that Mr. Meyer and every other member of Gun Safe Life has to get a license to possess a firearm. The answer to say, well, you can cure your harm by getting the license just makes no sense at all. That's the harm that we're complaining about. We don't want to have to get the license. And it's not just Mr. Meyer. There's another member that we specifically identified in the complaint. In paragraphs 4 and 18 of the complaint, we said this applies generally to Gun Save Life members. Everyone else in Illinois have to get these licenses. And then we submitted an affidavit from Gun Save Life's executive director stating that me personally, if I didn't have to do this, I wouldn't maintain this license to possess a firearm in the home. So there's more than enough support statement. And for those reasons, Your Honor, we ask that you reverse and order the district court to preliminary.
All right, was filed December 9th.
We'll take this matter under advisement and be in recess at this time.
Okay, so this was filed. Let's see, let me share this tab. So this is a Gun Save Lives v. Raoul. So this was filed in December 3rd, 2019, or not, yeah, 2019. Judgment affirmed. But I'll have to read through all this on my own. I don't put anybody through this whole thing. It goes all through their analysis. This is going to be some maddening reading. Figure out exactly where all that went. Okay. So, going to kind of switch some gears here. And I'm going to touch on, or want to kind of touch on a shooting, and then what's happening now after this shooting. This was a shooting in the at a high school in Oxford, and they're trying to try the parents for manslaughter in the case, and charge them with manslaughter for each child that was killed by this piece of shit. So let me play. Where's it at? All right, let me share this one. And I'm going to let this play mostly. And then just hit kind of brief on just how bad this could get.
Sharing shooting range videos, messages, and photos in court Thursday, Michigan prosecutors showing evidence suggesting that Ethan Crumbley's parents, James and Jennifer, were well aware of his interest in guns before he carried out a mass.
And listen how they frame that. They were well aware of his interest in guns. They can't say they were well aware of the mental issues this kid was having. Just that he was interested in guns. That's enough to make these parents liable for this kid's actions.
Massacre at Oxford High School.
Jennifer Crumbley didn't pull the trigger that day, but she is responsible for those deaths.
Facing trial this week ahead of her husband, Jennifer Crumbley is accused of involuntary manslaughter.
I've been watching
One
some of the
count
trial
for each
coverage.
schoolmate her son killed. Both parents have pled not guilty. Jennifer Crumbley and her husband are accused of failing to act even hours before their son's attack, when a school official showed them his handwritten note saying, "Help me," with a drawing of a gun.
They didn't do any number.
There's so many things with this that are absolutely crazy, besides the shooter himself, who the more they name this dude, the more they make him famous, the more they just encourage shit like this to happen as far as the shootings themselves. But, and we'll hit on a couple points, but
Number of tragically small and easy things that would have prevented all this from happening.
Prosecutors showing an Instagram story from Jennifer of Ethan and his father at a shooting range, and this video of Jennifer firing a weapon with her son just days before he killed 4 schoolmates. The defense team says Jennifer.
So that's already, listen to how they're skewing this. Oh, the kid was interested in guns. The parents were helping him with guns. Oh, this is evil. Guns, 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 guns.
Crumbly was a caring mother, pointing the finger at Ethan Crumbly's father when it came to gun safety.
She did not have it on her radar in any way that there was any mental disturbance, that her son would ever take a gun into a school, that her son would ever shoot people.
Then Johnson represents multiple victims' families.
You don't see any difference between either parent's responsibility, regardless of who was more interested in guns.
No, adults are adults. Both have a responsibility to make sure it is locked and secured.
On the first day of testimony, jurors also hearing from school employee Molly Darnell, emotional and describing the moment she was shot.
I locked eyes. And then instantly I see some movement. And so I looked down and I realized he's raising a gun to me.
And we could soon see Jennifer Crumbly on the stand herself. Her attorney says she will testify in her own defense in this unprecedented trial.
In this unprecedented trial. So let's hit that, and we'll shoot the breeze about it for just a little bit real quick. Let me get that off the screen. So here's the deal. This is trying to convict the parents for the actions of their child. And they're pointing to things that the child said, things that he texted. And a lot of it looks real bad now, knowing what the kid did. But how many times have we texted stuff that if people looked at it later and they took it out of context, would make it seem very much different than what it was? And this kid was not texting his mom going, I'm going to shoot these people. His mom never texted him and said, here, son, here's your gun, here's your ammunition, you go shoot these people. There's nothing there that says that. I've watched more the second day than I have anything with coverage from Uncivil Law. And if you're not following Uncivil, you need to check out Uncivil Law. I think I posted one of his links in another video. Matter of fact, let me look up Uncivil real fast, and I will post a link to his channel. Because he's covering this. This is the case that he's sticking with right now. And he's going to cover it from start to finish. And again, he is a lawyer. This guy knows what he's talking about, or can at least make a decent argument about a lot of things. So that's Uncivil. So if you want to kind of keep an eye on where this trial is going, and we've bounced back and forth in the chat talking about some of these things. But if you can find the parents guilty of manslaughter in this case, okay, what about a kid driving their car? Say they're just texting. They cause an accident. Someone gets killed. Now, with this case law, say the parents knew that the kid was texting when they were driving sometimes. So now you could actually go in, and if this case goes through, then you could go in and you could charge the parents with the actions of the kid, charge them with manslaughter for what their kid did. What about all these little gangbangers running around shooting people, shooting each other, robbing people? When we get them, do we start suing their parents, holding them responsible because they realize that their little fucking whatever is a shithead. Or say that they weren't, monitoring their child enough. A little bit different than this case, but it's all going to lead down that road. This will lead to some very, very bad case law, and it'll be coming if this goes through. Now, understand, I don't think these parents were the greatest parents in the world. I don't think they were the worst parents in the world. I think maybe sometimes they didn't pay enough attention to their son and some issues he was having. But I don't think they're responsible for what their son did. That responsibility lies with their son. He is the one who brought the gun to school. He is the one who started shooting people and murdered people. Those were his actions. The only way I think you would be able to make the argument that his parents suffered liability for that is if you actually did see texts where the mom was like, "Oh yeah, son, here's your gun. Yeah, just go shoot all these people and become a school shooter." If you could show that, then yeah, his parents are liable because they set that plan of action into motion. And what this comes down to, and where this is going to fall, are absolutely emotional arguments from a bunch of people who are anti-gun in the first goddamn place. And they're going to do anything that they can in any case that involves a gun to go after as many people as they possibly can. It will extend who someone could go after if, in some cases, say someone used a gun to go rob a store or something like that, or they murdered someone on the street to rob them. It's going to extend who the state can go after, which leads to a whole ball of wax, because it wouldn't just be for gun cases. And it wouldn't just be, say, going after the parents. What about going after aunts and uncles that were actually partially responsible for raising kids because, say, they had custody? Or it's going to lead to some really, really crazy legal precedent. And I keep saying that, but that's where it's going. That's where it's going to lead to. So it's definitely something to keep an eye on, because again, this is all about the emotional end of it. This is all about the gun. You hear the way they phrase the argument in the first place, that, oh, his parents knew he liked guns. Oh, here's his parents with him at a shooting range. Those are normal things for people in most cases that understand that firearms are tools. Train your children with firearms. Most of the time, something like this is not going to happen. Yeah. What if the parents did like mine did when I was, mid-teens or so? And they give me the gun that I wanted for Christmas, 30-30 lever action. What if I just have an accident with it and someone gets harmed? What if I did a completely self-defense shooting with a firearm that my parents had or that I had access to, but I'm in a state that says, hold on, you can't defend yourself? All of a sudden, that becomes a murder case instead of a straight-out self-defense case. It's Illinois and other states drive me crazy with Ford cards and stuff like that, because especially when it comes to younger people, they're not supposed to possess a firearm if they don't have their Ford card. What about letting your kids go to a shooting range with somebody? Say your friend is, excellent with firearms, very well trained, very safe with firearms. You let your kid go to the shooting range with them. I think there are probably exceptions for hunting to where my kid could possess a gun, on a hunt or something like that. But it's still going to lead to some absolutely horrible decisions from courts, and it will be used as precedent in other cases. And it's going to just, it's not going to stop there. By no means is it going to stop there. And there's going to be some parents that are really fucked up over some shit later where their kid does something, like I said, driving a car. Maybe their kid has a couple of beers and they are drunk driving and hit somebody. And then the parents are going to be sitting in court going, well, how the hell did I get here? Well, because you supported it in this case where this little evil bastard did something. You supported them holding the parents responsible. Now you're getting held responsible because your little shithead fucked up. There are plenty of cases when I was a kid, I would not want my parents to have been held responsible for shit that I did. I was the one being the shithead. So we'll see where this goes. They've got, I forget how many more days are expected to be used in this case. So I think it's only been 2 days so far. I forget how many more days they got to go. And like I said, if you want to keep track of the case, go over to Uncivil Law. He's doing basically any day this case is active, Kurt's going to be on it. And there's no doubt he might fire up a weekend show or something to kind of go over what happened during the week. But I'm telling you, this could get real dangerous for a lot of parents who think their little kiddies are perfect. And let's be honest, talking about his parents. What parent wants to believe that your child is capable of doing something like this? As parents raising children, there are plenty of things that happen sometimes where you don't want to acknowledge that your kid either did it or is capable of it or suffering from something. And a lot of parents are always going to believe that their kid's okay, even when their kid is not okay. And so far, the state, especially listening yesterday to Kurt's coverage, the state is blowing out the lines on this. They try to make a big deal about the parents having so many cell phones. And what it turned out to be is, first of all, their cell phones got confiscated. Then they bought a different set of cell phones, track phones or whatever it was, that weren't able to do things like online banking and stuff like that. So then they bought another set of cell phones because that's how they were doing a lot of their stuff. And the dude on the stand kept calling them burner phones, trying to lead the jury to believe this was some negative event. They were trying to cover things up. Now, these parents did leave their residence and go stay somewhere else. And they tried to make a big deal out of that. I'm in Alabama. I heard about all the death threats these people were getting down here. At the time, I still had some of my other social media stuff running and was seeing what people were posting about these parents. There's no way I would have stayed where I was at with the amount of hate those people were catching. And their lawyer did a really good job of explaining things yesterday. But still, you've got a jury, and I will be willing to bet most of that jury has been tainted by the coverage and will make completely emotional decisions regardless of the facts of the case. They try to make a big deal about the parents deleting social media. Well, again, with all the hate and everything they were catching on social media, there's no doubt why they shut down their social media. And when we come back to the issue that the state is trying to hold them accountable for what their son did. And even going through all the text messages and stuff, they never once showed a text message that said the parents told this kid to do this shit, or even put him up to it, or encouraged him to do so. So, hey, brother, we rolling straight con-fed, man. If it splits up, we ain't rolling with the Fed, baby. I'm all about a peaceful divorce. But if the Fed pushes it and things got worse, might as well go get it over with. So, yeah, it's getting pretty crazy on that front too, Gabber. there's just so much crazy shit going on around the country these days if you're actually paying attention to it. And it's where were you getting at, Warsaw? More killings. Yeah, I kind of lost your point in that whole stream. That's funny, Gabber. Now, if you got a banjo, brother, you got to learn how to play dueling banjos. That's the only requirement for owning a banjo. It's fact. It's written somewhere in some Bible or something. You got to learn dueling banjos if you get a banjo. So, you guys, I don't know. Like I said, if you want to follow that case, the best person to follow with that is probably Uncivil, because he's really keeping up with the case. He's going to be covering it every day. And I may start branching out and doing some stuff on what's happening with the states and the border. Rocada Law, if you didn't see his stream today, Nick did a bunch about this back and forth in between the Fed and the state and had some really good analysis on that. And anybody who tells you Texas is breaking federal law, and I went back and forth with a dude on X the other day about it when he said that. But show me the title and the statute that Texas is breaking, because they're not breaking a single federal law. Matter of fact, the feds are really pushing the state into a corner is what they're doing. So we'll see how that lands too. And like I said, I might branch out and start doing some stuff on that, because it really does come down to state powers versus federal powers. And if the federal powers in this case are not going to do their job, what options does the state have? There's another interesting oral argument, and oh God, should I go ahead and hit it? It was an FCC case. I think there were actually two of them yesterday that have to deal again with a federal agency overstepping their bounds and making up these regulations as they go. And that's an interesting case, and it will fall back into the Chevron doctrine and everything else that we've looked at on other streams, where these agencies are given huge deference and can completely trample people's rights. And the courts in a lot of cases will fall back to the Chevron that, these regulatory agencies need to make these decisions. No, they don't. If Congress wants something done, they create a law, and then they empower that agency to enforce said law. The agencies write regulations, and they go, they're only regulations. Yes, but those regulations have the force of law. Don't believe me? Break a regulation, you will be charged, you will be tried, you will be convicted. That's the way it goes. Look at ATF and a lot of their BS. So, yeah, Gabber, no doubt. I'm glad to see, and if you guys haven't looked, there are like 24 states whose governors have signed on with Texas and said, we will send our National Guard to Texas to aid Texas. And that's huge. That's 24 states willing to give the federal government the middle finger at this point and saying, we will back Texas up. I'm happy to say Alabama signed on. And I'd have to look up the list of the other states, and maybe over 24 now. I think Mississippi might have finally got off their ass, because before Mississippi was sitting there, and you had Texas, you had Alabama, Georgia, South Carolina, Florida, just all around Mississippi were signing on with Texas. And then I think Mississippi finally got off the bench and said, okay, I think we'll sign on to this too. So we'll see. This is See, I've been alive 47 years. I've never seen this many states actually stand up to the Fed. When's the last time they passed a law? A straight out law, I'd have to follow Gabber's link and look. They passed some gun law stuff with the Safer Communities Act. But that did some stuff with criminal code kind of mixed in there. But Jason, what's up, brother? So see, now all the cool kids are showing up. So I don't know, it's getting really crazy. And of course, there are more states that have basically said that the ATF and other federal agencies are not getting any help from their law enforcement. I think Alabama passed something like that about 2 years ago. It said when it came to firearms, they weren't helping the federal government, which is nice. We'll see whether they stick to it or not. So there's a ton of stuff happening right now in a ton of different parts of what we think about it is either states' rights or just freedom in general from government overreach and things like that. So I don't know, man. There's a lot of really interesting stuff happening for sure. And then like we listened to the other day with Todd Vandermine's arguments. And hell, since let me look. I wonder if I can find it just by his first name. No, that's something else. Hold on. Give me a sec. I'm gonna have to find this another way. Or if I can look it up just by his last name. That's so many damn tabs open right now, as usual. How is that not bringing up Todd's case? Give me a sec, guys. Cooking. There it is. I don't know why I wasn't bringing it up by his damn last name. I'll let this play. I mean, we already went through the two cases before this that this case talks about. So screw it. We'll play this one again. And this is Todd Vandermine. This is his case against Cook County for that same ammo tax horse crap. So we'll let it play. And it might be kind of instructive to hear that after listening to the other cases, so people can see where these judges are at on this one, which is pretty much the same way they were on the other ones, but they actually use these other cases kind of talking about them in this one too. So hell, we'll listen to it.
Good morning. Illinois Appellate Court, First District Court is now in session. The Second Division, the Honorable Justice Nathaniel House presiding. Case number 23-0413, Donald Todd Vandermine versus Cook County.
Good morning. My name is Nathaniel House. I'm a judge of the Appellate Court, and presiding over this case with me are Justices Mark McBride and Cynthia Cobbs. This case is being heard via Zoom, and we'll follow this procedure.
I wish I had
We'll allow
video
each
of this.
side in turn to have 10 minutes of up to 10 minutes of uninterrupted argument.
Billy up. What's up, my
after
brother?
which we will ask questions. The appellant will be given a few minutes for a rebuttal. Does anyone have any questions about how we're going to proceed?
HPS, I think I said hi to you, man. What's going on, bro?
Represents the appellant in this case. Please state your name.
And then Tread come in. Brother Tread, what's happening?
And who represents the appellee?
I do, Your Honor, Jessica Wasserman.
Thank you. Ms. Hardiman, you may proceed when you're ready.
May it please the court, Kate Hardiman for plaintiffs' appellants. At its core, this case is not about firearms. Rather, this case is about whether governments can single out and discriminate against certain constitutional rights for special taxation. When faced with that question, the United States Supreme Court and the Illinois Supreme Court have repeatedly held that the answer is no. To take just a few examples, the Supreme Court struck down a $1.50 poll tax in Harper and a 4% tax on paper and ink used by a newspaper in Minneapolis, Star Tribune. The Illinois Supreme Court similarly struck down a $10 tax on marriage licenses in Boynton. The teaching of all of these precedents is that no constitutional right can be singled out for special taxation. This principle must apply equally to the Second Amendment, and it renders Cook County's firearm and ammunition taxes invalid. Plaintiffs prevail for a simple reason on appeal. The basis for the lower court's opinion is no longer good law. This court's decision in Gun Save Life 1 has been abrogated in relevant part twice over, first by the Illinois Supreme Court in Gun Save Life 2 and by the US Supreme Court in Bruin. I'd like to start with Gun Save Life 2 from the Illinois Supreme Court. That case held that firearm and ammunition taxes burden a fundamental constitutional right, directly reversing the contrary holding of Gun Save Life 1. Now, to be sure, Gun Save Life 2 interpreted the uniformity clause of the Illinois state constitution. However, the court's holding that firearm and ammunition taxes burden a constitutional right was integral to its holding that the taxes violated the uniformity clause.
And this was argued last week, or this week.
In paragraph 28, for example, the Illinois Supreme Court, in paragraph 36, the court explained that where a tax classification directly bears on a fundamental right, the government must establish a closer tie between the tax classification and the object of the legislation.
And the ramifications from this go
scrutiny
far
in that
past just
instance,
Illinois.
in other words, where the tax burdens a fundamental constitutional right, we hold that the tax classification must be substantially related to the object of the legislation. The Illinois Supreme Court's ruling in Gun Save Life 2 therefore leaves nothing left of Gun Save Life 1. And the lower court's reliance on Gun Save Life 1 was improper. Let's also consider the US Supreme Court's decision in Bruin. Bruin invalidated the old test that was 2 steps and that the gun.
What we need is the Supreme Court to actually take these cases and decide them. But we also need the Supreme Court to tell these lower courts, which they have already, but they need to hold them accountable, that if you're not applying this constitutionally as we say you should, your decisions are absolutely invalid. But, you know, that's one of the reasons, like with Miller, okay, and we pretty well knew these judges were going to play games with Miller v. Bonta, another case we listened to this week. And come today, and Four Boxes Diner shot a video on it. These judges have decided to hold that, not even make a decision on it. They're going to hold it. And that decision is going to take forever because you've got to wait for another case about magazines to work its way through. And then they'll try to shoot it back down to a lower court, more than likely Benitez. And Benitez will tell them they're idiots, and then it'll bounce its way back up, and then they'll bounce it around some more. We need the Supreme Court to step in and pick these cases up, because they could. They could step in, pick these cases up, tell these lower courts, we're tired of your damn games. You're not following our direction, and just go ahead and pull these cases. But there's another avenue. Todd Vanderbine brought it up in one of his videos. Warsaw knows about it. We're trying to get a stream together to where we can kind of go over what Todd was talking about, which is to force the House Judiciary, the federal House Judiciary, to pull these judges into a hearing and then basically make them explain themselves and then give them a little bit of pee-pee slap and then send them back. Really and truly, they should be starting impeachment hearings for these judges to remove them from the courts. That's the only thing that stops judges from being able to play these games with these cases, is to actually hold them accountable. People are going to prison. People are losing their livelihoods over these unconstitutional laws. And these judges are sitting here playing games with it because it ain't affecting them. They agree with it, even though it's absolutely unconstitutional. And that just freaking drives me insane.
Save Life 1 court employed. The first step that is now invalid is whether text and history support the restriction. As Bruin put it, figuring out the original scope of the right based on its historical meaning. And then, of course, the second step under the old framework.
Now, here's a point, Gavin. Let me hit this real quick. I'm going to let this play.
Second Amendment right.
So I believe 100% the states should be able to govern themselves. And constitutionally, they can. But even with the states governing themselves, you need the judges in the state to follow their own damn constitutions. And in a lot of cases, you see it in California, you see it in Illinois, you see it in, I think Ohio was another one, where they won't even follow their own constitutions. None of these state constitutions gives the government the enumerated power to manage arms inside of their states. They don't. There are a couple of kind of close, which tells the government or gives the police in the government the power to kind of regulate how arms are carried, but they can't regulate the type of arms constitutionally. They can't touch the type of arm. They may be able to say you can't carry it concealed, like North Carolina may be one, but there's no state constitution that enumerates the power, says you, the government, the state government has the power to regulate arms. None of them. Not a single one. It's not there. And yes, I nerd out and I go through and read all this crap. And then when you look at court decisions, because most of these cases never should have had to make it to the federal courts anyway. They should have been shot down in state court as being unconstitutional. But again, these judges will decide things on ideological lines, not based on the constitutional restrictions on government powers. And that's what drives me up a freaking wall with it. What's up, Tactical? You doing okay, Skilly? Yes, Jason, I'm there with you. Because like I said, the Supreme Court does have the power. They are the Supreme Court. They do have the power to shut this BS down, and they won't. And these lower courts keep using like the Heller decisions and stuff to say they can restrict these things because Scalia in his infinite wisdom gave them all the ammo they needed to be able to say shit like that, which was that this isn't, all rights aren't unlimited. Show me the limitation in the Second Amendment. Where's that? It's not there. And we actually heard that dickhead in the Miller case the other day argue that the Supreme Court separated out arms that the militia could own and arms that the people could own. Let that sink into your head a little bit. He's saying that, these guns that are useful in militia service only belong in the militia service. They don't belong in private hands, even though the private hands are the ones that serve in the militias. I said it earlier on the stream. I've said it for the gymnastics they go through. If they did that physically, they would actually be able to stick their heads so far up their asses that they would turn themselves inside out and be a giant walking colon. That's literally what they're doing figuratively in these cases. So even if we went back to states being able to manage their own affairs, which I 100% believe they should. And that's the way it was supposed to be. The supremacy clause, all this other core shit, this stuff doesn't come around until you're looking at after the Civil War. And it was bad then, and it's horrible now.
Rights and the severity of the law's burden on that right. Now, Bruin altered and overruled the second step of that framework. The Bruin test now asks whether plaintiff's conduct falls within the plain text of the Second Amendment. If plaintiffs are Americans who seek to keep and bear arms in public for lawful purposes, this step is satisfied. There is no longer any historical analysis in the first step. If the first step is satisfied, the burden shifts to the government. The government must then justify its restriction by pointing to representative, relevantly similar analogs with a focus on the founding era. This piece is all about history. Now, this holding in Bruin also squarely abrogated Gun Save Life 1 holding.
I'm going to pause it right there again real fast. And see, the funny thing is Bruin tells you have to find a historical analog from the time of the founding to support these gun laws. These leftist assholes want to go back to the period right after the Civil War, or around the Civil War, where there were restrictions on arms, mainly restrictions where black people couldn't have guns, all this stuff, absolutely racist horseshit. They want to rely on that as an analog for laws now, even though it says you have to do it at the time of the founding. This moron in South Carolina the other day in the debates for constitutional carry there brought up Dodge City. That's not the case when you want to look at actual laws and shit. That's not the case you want to look at, because that actually came down to when you look at it on its merits. And he brought up the shooting at the OK Corral. What that proved is that if you don't bow to the government, they will kill you to disarm you. Not the win this guy thinks it is when you actually sit down and look at it. Barnaby, what's up, my brother?
paragraph 57 of Gun Save Life 1, it is clear that this court applied the now invalid two-prong test, and specifically the second prong of that test. This is so because the court reasoned that taxes on firearms and ammunition do not implicate, quote, the core of the Second Amendment, because they do not restrict the ownership of firearms and ammunition.
Excuse me, Ms. Hardiman. I know I promised you 10 minutes of uninterrupted presentation, but here, did you file a motion for summary judgment below, or a motion for a judgment of any type in your behalf?
Your Honor, the decision below is decided on a motion to dismiss, I believe. So
Okay.
we're not even at the summary judgment stage. We lost in the motion to dismiss.
So what was the basis of the motion to dismiss? Was the first case, Gun Save Lives case, and that doesn't apply that you're arguing.
That's correct, Your Honor. The court below held that these taxes do not implicate the Second Amendment at all. And our position is that that holding cannot be squared with the Illinois Supreme Court's ruling in Gun Save Life 2 and the United States Supreme Court's decision in Bruin.
There are some other bases raised by the state for dismissing this claim. And what about those issues?
Yes, Your Honor. So we believe that this court could decide on the issues that I've discussed alone. However, the other 4 issues are briefed and are before you. So we do think it's important to provide guidance to the lower court. The county raised 4 other bases for dismissal. So the first is that plaintiffs are seeking an advisory opinion. And this is simply not the case because plaintiffs are seeking damages from the payment of an unconstitutional tax. We're not seeking to invalidate the old version of the ordinance that Gun Save Life 2 already dealt with. Rather, we're seeking, just as under Carey v. Pifus in the United States Supreme Court, financial compensation for the unconstitutional taxes that we paid. The county also raises a number of arguments about pleading and whether or not we have stated a claim that the taxes infringe our Second Amendment rights. And here, Your Honor, most of the debate between the parties is about the meaning of the word infringe. And we have cited to you 2 founding era dictionaries, as well as decisions from
Todd is
2
the named
federal
party in this
Court of
case.
Appeals that hold
And this is his
that
YouTube channel.
infringe means not, as the county argues, to destroy, but rather to hinder. So any tax hinders the exercise of here Second Amendment rights because it makes that right more expensive to exercise. Also, the county argues that plaintiffs can't challenge this tax through Section 1983. Now, this argument can be easily dismissed. The county invokes the Tax Injunction Act, but that plainly on its face only applies to restrain federal courts from interfering with state taxation systems. It leaves a remedy in state court, and obviously we are proceeding in front of you in state court. Lastly, the county argues that the Supreme Court's fee jurisprudence supports their position, not the county, not plaintiffs. However, those cases that the county cites all support plaintiffs. This is because they only hold that fees that go to defraying the cost of a licensing scheme are permissible. Now, 2 problems with that here. We don't have a fee, we have a tax. The Illinois Supreme Court held in paragraph 5 of Gun Save Life 2 that this is plainly a tax levied under the county's taxing authority. And also, the proceeds here are not going to defraying any administrative costs with the scheme. This is a revenue-raising tax that is going into to fund the county's
something else. That's why you saw me smiling.
objectives. So those precedents, to the extent that they're even applicable, support plaintiff's position. I'm happy to address any further questions your honors have.
Any questions?
Yeah, why are we even here? It's
Okay,
unconstitutional.
someone have any
Let's go have
questions
lunch.
either? Ms. Wasserman, you may proceed.
Thank you. May it please the court. My name is Jessica Wasserman, and I represent the Cook County defendants. This court should affirm the decision of the circuit court for 3 reasons. First, plaintiffs seek an advisory opinion that the already invalidated pre-amendment ordinance violates the Second Amendment. Second, the circuit court correctly determined that this court's prior decision in Gun Save Life v. Ali mandated dismissal. And third, even if Gun Save Life 1 is no longer good law, plaintiffs have failed to state a claim that the ordinance implicates the plain text of the Second Amendment.
Again, no matter what,
So
we win.
first, plaintiffs improperly seek an advisory opinion. They argue at oral argument that they don't seek an advisory opinion because they seek damages. However, they do not address the defendant's argument that they could have sought damages under a uniformity clause claim. The pre-amendment version of the ordinance was already struck down under the uniformity clause claim. And just because the plaintiffs waived that claim here doesn't create an active controversy with regard to the Second Amendment. So only the post-amendment version of the ordinance is at issue today. Next, this court's Second Amendment analysis in Gun Save Life 1 remains good law. The Gun Save Life 1 court's Second Amendment analysis is entirely consistent with Bruin. There, the court explained that its analysis involved a textual and historical inquiry to determine whether the conduct was understood to be within the scope of the right at the time of
Completely interest balancing, and Bruin says you can't do that. How is that?
Further, in determining whether the ordinance fell within the scope of the Second Amendment, the Gun Save Life 1 court held that the challenge taxes do not restrict the ownership of firearms or ammunition. And in support of that holding, the court noted that the taxes weren't prohibitive or exclusionary. This is entirely consistent with Bruin's blessing of shall issue regimes. They noted that those kinds of regimes are presumptively constitutional while recognizing that if they involved exorbitant fees or lengthy waiting times such that it, had the effect of prohibiting someone's
That was
ability
on
to
carry
bear arms,
permits.
then
That was not on
open up to a constitutional challenge.
restricting your
And
right
further,
to
that
purchase.
analysis in Bruin from Bruin's
I
footnote
don't
9,
agree with it on
this
the
court has
carry
already
permit,
held
so-
that that is part of the plain text analysis. In People versus Gun, this court, relying on Bruin, concluded that it didn't need to engage in a historical analysis because an $150 fee wasn't exorbitant. And the same is true here, and plaintiffs have done nothing to distinguish
Those damn
Gun
mental
from
gymnastics, man.
Gun Save Life 2 in the Illinois Appellate Court also didn't overturn the Second Amendment analysis in Gun Save Life 1. In fact, the Illinois Supreme Court in Gun Save Life 2 explicitly stated that it didn't need to consider the federal constitutional claims. Moreover, the plaintiffs in that case actually asked the Illinois Supreme Court for a petition for rehearing on the Second Amendment issue, which the court denied. So the court made explicitly clear that it didn't wish to speak on the Second Amendment issue. And even if that weren't enough, the Supreme Court, the Illinois Supreme Court's recent decision in Calkins versus Pritzker offers further guidance that not everything that burdens the Second Amendment necessarily implicates the plain text. The Calkins court explicitly held that a Second Amendment claim was waived in part because equal protection and the Second Amendment are analyzed under different standards.
How do you get there? That when something directly burdens a right that is constitutionally protected, that it doesn't implicate the text that protects the right. Walking colon, just inside out.
And in support of that, the court, relying on Bruin, explained that plaintiffs needed to establish that regulated items fell within the category of bearable arms that are commonly used for self-defense today.
No, that's
In
not
their
what
reply brief, plaintiffs tried to discount.
They said all lawful purposes. And we saw this in Miller. They try to focus on, well, it has to be for self-defense, and you basically have to fire the gun in self-defense. And even though I can find all of these cases where people have used these firearms for self-defense and actually fired them, they just dismiss all that. Fuck it, doesn't matter. State always wins.
Calkins entirely simply because it dealt with waiver, but they overlooked that those substantive holdings were integral to the waiver analysis. And as such, they bind this court in its decision today. But even if Gun Save Life 1 is no longer good law, plaintiffs have failed to state a claim that the ordinance implicates the plain text of the Second Amendment. The Second Amendment presents several conditions for plain text coverage, including whether the regulated conduct infringes on plaintiffs' right to keep and bear arms. Plaintiffs here haven't pleaded that the ordinance affected their conduct at all, let alone infringed upon. Their assertion that anything that even touches on the Second Amendment is presumptively an infringement is simply inconsistent with Supreme Court case law. For instance, as I've mentioned, the Supreme Court's shall issue discussion in Bruin has provided clear guidance that infringement requires more than a simple processing delay, firearms training, or the imposition of some kind of administrative fee. Similarly, Heller made clear that laws imposing conditions and qualifications on the commercial sale of arms were presumptively constitutional. In their reply brief, plaintiffs argue that the taxes must infringe on their ability to keep and bear arms simply because they couldn't have purchased their desired weapons if they hadn't paid the taxes. But that's also true of an ordinary sales tax and allowing a purchase price to be charged at all. At oral argument, plaintiffs argue that the extent of the brief is irrelevant, and instead they try to piece together a host of case law from other constitutional contexts to create a rule that the dollar amount doesn't matter, and if a tax singles out a constitutional right for special taxation, it's per se unconstitutional. And as a preliminary matter, this contradicts what they argued in their opening brief, where they argued that First Amendment jurisprudence was, quote, rendered inapplicable to the Second Amendment by Bruin, which sets out a single standard for applying the Second Amendment. They then switch gears in their reply brief and cite a variety of case law in other contexts to try to create this rule. But even if this court considers the cases that the plaintiffs cite, they're inopposite. At oral argument, the plaintiff has brought up Harper versus Virginia State Board of Elections, which involves
this is akin to, so when they mention speech in some of these cases, this is akin to the government telling me I cannot speak, not right now, not ever, from the time I'm born till the time I drop dead, unless I pay their fees. And I can wake up in the morning, speak all day, speak to people all day. The only time that I have to jump through some special hoops is in special circumstances where I may tie up an area or resources for a government agency, a state or a city or something like that. That is the only time I have to pay a fee to speak. Other than that, I can speak all I want. I can speak all day. See me doing it. Ha, ha, ha. I haven't paid any fees to speak. Much like with firearms. I can carry my gun all day long. It doesn't interact with anybody else. The only time that thing clears its holster is in the event of, say, I got to clean it, I've got to practice with it. It doesn't, I don't just run around the whole time pointing it at everybody, putting everybody in danger.
Involved a poll tax in the Jim Crow era. But that case was decided on equal protection grounds. And the issue there was that the tax caused invidious discrimination. Here we have no kind of discrimination claim or anything even remotely similar.
Tell that to some low-income people in
Further,
Chicago,
the Supreme Court has consistently held that the First and Second Amendment are subject to different kinds of restrictions. For instance, whereas the Supreme Court has consistently held things like prior restraints are presumptively unconstitutional in the First Amendment context, Bruin and Heller have made clear that prior restraints, background checks, things like that are presumptively constitutional in the Second Amendment context. And
again,
I would open it up if the court has any questions at this time.
All right. Any questions?
I have a question. So would you agree that at the trial court level, the court, maybe I'm wrong, but did the court dismiss this? I'm sorry, the court dismissed it based solely on the judge's belief that she had to follow Gun Save Lives for one.
So the judge noted that, yes, she was bound by Gun Save Life 1, but she also went on to explain that Gun Save Life 1's reasoning was consistent with Bruin. And, in this case, the plaintiffs hadn't done anything to distinguish that case and showed that it implicated the scope of the Second.
But she did not address any of your other arguments, did she?
No, Judge, not in her written order.
And normally, if there's a stated claim on a motion to dismiss, if a claim could be stated, well, all right, let's go back to if she is wrong that Gun Save Lives 1 has any life at all, and she was bound to follow it. If she erred as a matter of law, we could send this case back simply because she erred in her determination, couldn't we?
Well, Judge, I would note, or Justice, I would note that this court can affirm on any ground
Yes,
present.
no, I understand that, but
Yes,
the
and
judge in this case relied on a sole ground. And oftentimes when that occurs and that ground is wrong and the parties haven't had the ability to argue why your other reasons for dismissal are incorrect, that they haven't even really had a hearing in the trial court. Would you agree? I mean, I know of cases where we've done that, but my question to you was the fact that she relied on a case that perhaps many would say is no
Yes, ma'am.
longer law was her sole basis for dismissing the complaint.
I'll
wasn't
tell
it?
you, there's another
well, so
instance
Judge,
my
I'll
gun
note
is
that there was
cleared its
oral
holster.
argument on the motion to dismiss where all of these arguments were raised.
Yeah. Well, I guess my
So Friday, I was in a big meeting. Everybody had to be there, everybody from the college. And we were walking out, me, a few other people, some people who were above me, I'm not going to name names or anything like that. And then some people that work in another area of the college that I'm familiar with because I've worked with them in other cases. And they were serious because we had to go over mass shooter and all this, watch this video on run, hide, fight. And they're seriously worried because the area they work in is very restricted. It's not like if someone came in the front, they got another exit. And one of the other instructors, the woman was like, if someone came in like that, we're dead. There's nowhere we can go. And obviously if they shut the door, if someone really wants to get in, they're going through that door. And another person that knows me really well, that I've worked close with, was like, I'm just going to find Coop because that thing. So, and then he keeps some stuff in his vehicle. Like I know a lot of people do at college. A lot of women around there, I bet you money they got them in the purse. So, but we walked out and we were talking about it, and it's like, here, he's carrying a 360, or he's got a 365. They were asking about carry options. And I was like, Clint carries, a 365. I know some other people that, in their outside world, they're carrying 19s like I am. And they asked about size and stuff. So I showed him mine versus a 365. So I cleared the holster, safe directions and everything, showed him, and was just kind of explaining some carry options to him. And one was kind of worried, they didn't carry before. And it was like, there's nothing to be afraid of. Just get the training, train with the firearm, and you're okay. And that's what school policy was about carrying. Balance that against someone coming into the school and shooting and then get back to me, because I'd much rather be in a situation where I had something to defend myself versus that run, hide, fight video where you've got people trying to pull staplers and, I shit you not, surge protectors and whatever else from their desks trying to address a shooter. It's mind-numbing to me.
The question isn't clear enough. The judge didn't decide this case on any other ground except that she was bound to follow first district precedent. Is that correct or not?
Judge, I would say that's correct, but the judge also explained that the analysis that the first district did applied with equal force in this case.
But that's because she held that case is still good law.
That is true, yes.
Okay, all right. All right, well,
So she's
in any
decided the
event,
case
and you're saying
on
it's
really
advisory
shitty
opinion,
law.
and yet they're not asking to have any law declared unconstitutional. They're asking for their money back for paying these fees. Is that right?
Well, Judge, their damages claim relies on the Second Amendment being declared as unconstitutional because they only bring a Second Amendment claim here.
Okay, but they're looking for money, correct?
Yes, Judge.
So this wasn't a declaratory judgment, was it?
So yes, I believe they asked for both damages and declaratory judgment.
Okay, but the court never reached that anyway. All right. That's all I have. If the judge is wrong about, in what case do you suggest that actually would hold that Gun Saves Lives 1 is still good law in light of Gun Saves Lives 2 by our Supreme Court, which we are bound to follow?
Yes, Judge. Well, and I would point, I believe in our brief, we cited the Williams case, which states that an opinion that is reversed but not vacated still retains some precedential value. And the fact that the Supreme Court explicitly said it was only addressing the uniformity clause issue and not touching the Second Amendment means that the first district's reasoning with regard to the Second Amendment still retains.
Dude, I
some
want to build some
precedential
ZevTech
value.
stuff. I've looked at their
And then
products and I
enlighten me
want to.
how Williams actually supports the argument you're making. The Supreme Court vacated, reversed, and basically, I don't see that case has any precedential value. But explain to me how the Williams case really supports what you're trying to argue.
So it draws the analogy that, there's a difference between vacating and reversing in part. And because
But the court didn't vacate in part, did they?
They reversed in part.
Okay, they didn't vacate in part.
No, it was just reversed in part. So, whereas the vacating would cause, no precedential value.
And didn't the court say that it's reversing under the uniformity clause, didn't need to reach
correct
the federal constitutional claim, which that's supported by well-established precedent, isn't it?
Yes.
Yes, Judge. The court.
Okay, but so what? I'm not sure why I understand
So
this
why are we
Williams
here?
case you're citing. Recall the facts and tell us why.
Here's the difference, I think, and I wanted to ask Ms. West. Reversed in part means part of the case is left intact. For example, don't we have a different case if the Supreme Court in Gun Saves Lives 2 had said, we agree with the Second Amendment finding of the appellate court, but we find that the uniformity, therefore we reverse, then they would be bound by it. But here, they said, we're not going to even consider the second. It was reversed in whole. Reversed. And the distinction is a reversed case is different from a case that's reversed in part. Isn't that true?
Yeah, they look freaking sweet.
Yes, Judge. And, similar to what you said, the fact that's important here is that nothing was done to disturb that Second Amendment analysis. So while it might not retain the same precedential value, nothing's been done.
It doesn't have any value. I mean, it's just,
The court said
rendered.
Court said it did not need to reach the Second Amendment argument because the statute was unconstitutional under the uniformity clause. And there was no reason for the court to reach a federal constitutional issue when it had already found under the state constitutional clause that this law was unconstitutional.
Now we'll see whether
I don't
these
know that
judges
there's anything
uphold this
left,
shit. So.
And I'm not sure I understand your argument still.
So yes, and it's our position that nothing has been done to disturb the analysis there. So even if the case doesn't have binding authority, it's still the analysis is completely consistent with Bruin. It's completely consistent with doing a plain text analysis. And even if the court redid the plain text analysis here, like our last point, we believe that it would come to the same
It's like
conclusion.
getting continually whacked in the face with stupid.
Okay. But it carried no more weight than just if a lawyer had made that same analysis. I mean, it was not binding.
So, Judge, again, it's just our position because it wasn't disturbed. But we would rest on our briefs on that point.
All right.
Again, we get
Any
back
other
to our
questions?
defense of this whole thing is the government wins regardless.
I don't. All right, Ms. Hardman, you make a brief rebuttal.
Thank you, Your Honor. So just picking up on Gun Save Life 1, our contention is that it has zero precedential value. It was reversed in whole. Gun Save Life 2 reversed a grant of summary judgment that the district court had affirmed and remanded for entry of the opposite summary judgment. Under People v. Brown from the Illinois Supreme Court, it effectively there took the place of the lower court and granted summary judgment for plaintiffs. Therefore, we think you can decide this case on the ground alone that there's nothing left of Gun Save Life 1. I want to respond to the contention that Gun Save Life 1 is consistent with the plain text analysis of Bruin. This just totally misses the point that Gun Save Life 1 was a step 2 analysis. It discussed the core of Second Amendment rights,
interest balancing.
and it
And
found
Bruin
that
says you
the firearm
can't
and ammunition
interest balance.
taxes don't impose a substantial burden on Second Amendment rights. Those are indisputably step 2 inquiries. They are not step 1 inquiries under the old test that Bruin invalidated. I also want to briefly address the county's appeal to shall issue regimes and exorbitant fees. And this comes from footnote 9 of Bruin. So those cases all dealt with licensing fees, not a tax levied pursuant to the taxing authority, which is what we have here. So footnote 9 is entirely not applicable to this case and these facts. Moreover, Gunn, which the county also cites, dealt with the Illinois licensing fee, also not applicable for the same reason. Here we have a revenue raising tax.
And I do want to say, I misspoke earlier. This is not a fee case. It is a tax case. And there is a distinction, as you've already argued and given us the reasons why. So I misspoke. It's not a
Thank you,
fee
Your
case.
Honor. Thank you, Your Honor. Also on Calkins, which is from the Illinois Supreme Court, it's important to note that in that case, plaintiffs expressly disclaim a Second Amendment claim. So that case stands only for the proposition that there may be no burden on Second Amendment rights when plaintiffs do not argue that there is a burden. It does not support the county's position here. On the stating a claim arguments, just briefly, this is not a qualification on the commercial sale of arms under Heller, and that is so for 2 reasons. This does not fall into the language about a sale because it's levied on the purchaser, not on, say, the firearms dealer. We think that language from Heller is meant to regulate firearm dealers who need to get a license in order to sell arms. It wouldn't fall or encompass.
Yet
purchasers
another
as
reason
we have
Heller
here.
was shitty.
Second, Heller required that any of those qualifications or conditions must be, quote, long-standing. And under Bruin, whether or not something is long-standing is an argument about whether it is deeply rooted in
Oh,
history
hell
and
no, that
tradition.
ain't bad at all, bro.
Therefore, that language from Heller
62
actually
bucks?
supports
Damn.
plaintiff's position that the county needs to ground its tax in history. And it has not done that below. It has not even attempted to brief history to this court. So that language from Heller is just not applicable here. Lastly, the county, 2 final points, Your Honors. The county argues that this tax is akin to a sales tax. That is just plainly not true. Plaintiffs would not challenge a generally applicable sales tax.
No, dude, I can
Here
find
we
it,
have
trust
a
me.
tax that singles out a constitutional right for special taxation. And therefore, the precedents of Harper and Minneapolis Star Tribune are directly on point. The principle, even though they were in different constitutional contexts, is the same. Constitutional rights cannot be singled out for special taxation. If that is the case for First Amendment rights, it must be the case for Second Amendment rights.
Yeah, what if you have to pay a
After
tax
all,
to protect
the
yourself
power to
against
tax
illegal
is
search
the
and
power
seizure?
to destroy, as Chief Justice Marshall once recognized.
Don't pay
It
your
opens
tax, government
Pandora's
just gets to
box
come into your
for this
home.
court to allow government
Search
to
everything you
single
got.
out a constitutional right it disfavors for special taxation. If this tax is okay, the right to counsel can be taxed. The right to any other constitutional right that this court favors could be taxed as well.
Oh, hey, you can't
This
plead the
court should
fifth if you haven't
reverse
paid
the
your tax
judgment
yet.
below and remand for further proceedings. Thank you for your time today.
All right, thank you very much. The case was well briefed, well argued. We will take it under advisement and a decision will be entered in due course. Have a great day. Thank you.
All right, so that's Vandermeide v. Cook County. So an extension of the People's or Gun Save Live case 1, Gun Save Live 2, which Gun Save Live was more on the FOIA card. Gun Save Live 1 was completely just shredded, I think, when it went to the Illinois Supreme Court. And that's, again, another oral opinion or another opinion I'll have to try to look up and find and kind of break down in between everything else. So in this case right here, argued this week, Freedom Steel, I posted his link in the chat. That's his channel. He is the one in this lawsuit, Todd. And we're trying to get together, me, him, trying to get John Crump, a couple other guys. Warsaw's the one who's kind of leading the charge on it to get everybody together so we can do a stream about how we can get these justices up in front of the House Judiciary Committee, because the House Judiciary Committee has a control over that. They have oversight over these courts. And that's another battle we need to fight. Matter of fact, let me look, and I'll post a link to the video here of Todd laying this out. All right, so this is a link to Todd's video, and he's got a lot of stuff going on, man. You know, with his wife, I believe his grandson or nephew, grandson, something like that. So we'll see when he's got the time to actually get into this. At some time in the future, we might do a stream talking about the stuff, even if Todd's not available to be there, because Todd brings up a lot of good points. We can push this with the House Judiciary and try to get them to call these judges up into Congress to testify to these things. And some of the judges that would be really important to have are the judges that have written dissents on these anti-gun cases, where these anti-gun judges have went completely against the Constitution and upheld these anti-gun laws. There have been some judges who have went and wrote their dissents, basically tearing apart these other judges. So it would be great to get them up there to testify. I would like to see impeachment hearings for these folks, because there are people going to fucking jail, losing their livelihoods, and in some cases, when it comes to law enforcement and law enforcement being called to enforce these unconstitutional laws, people have lost their lives because they dared to stand up to law enforcement for their rights. So yes, people, hell, sometimes even my wife doesn't understand why I'm in this so deep and trying to put this information out here. It's because it's just a fucking giant snowball where people are losing their lives, losing their livelihoods, losing their jobs, losing their families over stuff like this, over completely unconstitutional gun laws. And if that doesn't get underneath your skin, nothing will. So that's where we're at. But anyway, guys, I'm going to end this one. I'm going to take a break, hang out with the fam for a while. Hopefully see you guys in either Dark's chat or Tactical Turkeys later. Hang out and maybe talk about some topics that maybe aren't so heavy. If you guys want to go back and look at part of this video where we talk about the where the two parents are being charged with manslaughter for the acts of their son, that's another part that, kind of heavy, but that's going to lead to some really bad law if these parents are convicted for the actions of their child. People are looking at this on a very emotional basis, and they're not really looking at this rationally. So much like these judges with gun laws. So, but anyway, guys, I am getting out of here. Hold on. Yeah, let me pull them, brother. I'm glad you said something. That one's uncivil. Let me post uncivil again. I'll post these other ones too. So if you want to look at the other case we were talking about with the two parents getting tried, this is uncivil. He'll be covering the trial start to finish. And he gives a lot of good analysis of a lot of these things. Let's see.
I'm hungry.
If you're hungry, you can eat some chicken Alfredo, girl. All right, let me see. Damn it. copy. This is Dark's channel. Dark normally runs decently late. Tactical turkeys tend to be on around 8:30 or so, and then they run sometimes into Dark's channel. Sometimes they'll shut down before Dark goes live. And there's a couple other channels I'll post real quick. So this is the Tactical Turkeys, bunch of good guys. Then let me pull up Skilly's channel. I'll throw Skilly's channel up there to you. There he is, Tactical Skillionaire. This is another really good dude. Another good guy to follow. Does some really good content. Nah, dude, you're fine. You're fine. I'm glad you said so. I should have put all their chats or channels in there. Matter of fact, let me throw up another one. Jason Ewing. You will see Jason in a lot of chats. He was in here today. A lot of times you will see his wife. A lot of times you'll see his wife in chats and him supporting channels, posting links. You'll see Carbon Q. Just a bunch of really good people, man. Tons of really great people to follow, to watch. In different areas. Some might be firearms, some might be kind of prepping, some are just freedom related completely. My channel, a lot is on firearms and firearms laws and stuff like that. And some gun content, building guns and stuff. I'm kind of all over the map, just depending on what's happening. So anyway, you guys follow the turkeys, follow Jason, follow Skillionaire, follow Uncivil if you want to get into that end of it. And other than that, we'll end it as always. You perps be cool. Keep that thing on you or near you at all times. And love each and every one of you guys. I'm out.